Morning.
Thank you, Mr. Chairman. Please allow me to give a little background to this bill before us, 1573. You may remember the scandal regarding Bledsoe, a facility in Tennessee where 2 New Hampshire lads were sent. When Cassandra Sanchez, child advocate, went there for a visit, she was appalled, and rightly so. She decided immediately something must be done to change the way we send people to facilities and asked me to put in a bill. This was done on the fly because bill sponsoring week was about to end. So the original Bill 1573 is a placeholder. There are at least 3 groups that oversee children in need in New Hampshire. One is the Office of the Child Advocate. 2 others reside within DHHS. One is Children's Behavioral Health. The other one is DCYF. I asked them to come up with one amendment, which would be one of those replace all amendments for the placeholder. I kept at them, and while they got closer and closer and closer to unanimity, squaring the circle, great rejoicing in the land, they could not ultimately come to unanimity. The sticking spot was how exactly facilities were to garner state approval. The Office of the Child Advocate has it one way. They want such facilities to be contracted. That is Amendment -0428. DHHS has another way of doing it. They want such facilities certified. That is -0427H. When the committee researcher gets here, she should be armed with copies of both of those if you don't somehow have them already. The bill you may have read is the placeholder. You may wish to read amendments 0428 and 0427 because these will be the ones put in play. The difference between the 2 amendments is mostly in the middle of the second page. On 428, it is starting at line 9, on 427 at line 18, and you should get some copies. In my opinion, the amendment from DHHS is the superior one. To come up with a formal contract, as the Office of Child Advocate would have us do, is a good thing, except contracting takes a lot of time and effort. The needs we have to make sure a facility is up to standard can adequately be addressed by the DHHS amendment, in my opinion, without the long time delay that will need. So with that, I put this bill into play, Mr. Chairman, and am willing to take any questions.
Thank you. Are there any questions for Representative? Seeing none, thank you, sir.
Thank you.
Next, I'll call up OCA Attorney Lisa Massio and Cassandra, right?
Good morning. For the record, my name is Cassandra Sanchez, and I'm the child advocate for the state of New Hampshire.
Good morning, Attorney Lisa Massio. I'm the Associate Child Advocate and our policy person.
Thank you. So we are here today in response to what the Office of the Child Advocate uncovered this summer at Bledsoe Youth Academy. I do know many on the committee are familiar, but I'm just going to briefly touch on what occurred in July during a site visit out of state. So the Office of the Child Advocate traveled to Tennessee, to Gallatin, Tennessee, to visit children in a facility called Bledsoe Youth Academy. This facility is certified by the state of New Hampshire as a level 3 treatment facility. We went to visit youth there, and during our time visiting the facility, which we shared our report that came out about a month after our visit, we found horrifying conditions where our New Hampshire children were staying. The standards at this facility were not standards that the state of New Hampshire would agree to for our own children. They were degraded in this facility. They were physically harmed by staff. There were excessive restraint techniques used at this facility, as well as encouraging youth to fight peer-to-peer in order to earn incentives and be free from future harm from staff in the facility. What we learned from these children is they were encouraged by staff all the way up to the director of this program to engage in behavior where they would either taunt or harass their peers in order for them to feel safe in the facility, because they were told that if they did this, they would be protected from future harm. The children were returned about a month after the OCA's visit to this facility in Tennessee. Upon us seeing the conditions in this facility, meeting with leadership, meeting with the clinical team, and holding very high concerns for the safety of our children, we immediately called DHHS from the parking lot of the facility before we were done our time there. It took an additional month for these children to come back to New Hampshire. Once they returned to New Hampshire, we had an opportunity to meet with them in residential facilities here in state and have follow-up conversations and check in with these children to see if they felt safe now and to learn more about what occurred for them in that additional month time frame. What we learned from that additional month time frame was absolutely horrifying. These children were targeted by staff. Some were pushed, and their items were broken, their personal items. They were told that they were going to be sent to another facility and that there was going to be further harm in that facility. They were told by staff that they were gang affiliated and the staff were going to send gang members after them and their families, threatening to kill their families. These children lived in complete fear. They were so grateful to be back in New Hampshire. They are doing better now, but are still to this day struggling with the aftermath of the trauma that they suffered while at Bledsoe Youth Academy. This is a facility that our state certified and our state entrusted to care for our children, and they were not providing any type of care. We know our children that end up in residential facilities already carry with them a plethora of trauma, whether it be what occurred to them in their biological family home, the trauma of being removed from those family settings, and then having to live in a setting with peers who struggle with a lot of behaviors, and they're exposed to many things when they're in these settings. And so rather than being able to send these children to a facility where we could trust that they were going to provide them not only the treatment that they needed, but adequate care and humane treatment, our children got otherwise. So this is why we sit here today and really urge the committee to take a look at the process of certifying facilities in New Hampshire. Is that enough? Are we gathering enough information currently to ensure that our children will be safe where they are being placed? And the Office of Child Advocate feels strongly that the certification process as it stands right now is not doing that. Lissa is going to share with you some of our recommendations for amendments to the bill to further strengthen this process, while also acknowledging that we do understand the contracting process can take some time. We do feel that our children deserve what is best for them, and if it takes time to make that happen, then we need to take the time to adequately assess them. But we do also understand that there may be times where a child may be waiting in an emergency department. These are probably the most calls we're getting day to day currently, where children are waiting in emergency departments for a further placement. And so because of that, in the work that we did work in so that they can be placed at a facility while undergoing the contracting process, so that we don't let go of the fact that we need to do the further assessment, but we start with that initial certification assessment and continue to assess the program while the child is there until a contract can be completed.
Thank you. I just wanted to touch very briefly on some of the concerns. And we did hand out copies of the Bledsoe report, the initial August 8th, which delves into this issue a little bit. But in the months since then, we've learned even more. So I just do want to reiterate that what we know is that currently kids in care of the state, being placed by the state, are being harmed. And under the current rules, laws, administrative rules, and procedures, and the current BCBH system of certification and oversight, that's happening. They're being harmed. So some of those gaps we saw was, how could New Hampshire children have been placed at a facility in Tennessee without BCBH ever visiting that facility? There were 0 visits before that facility was certified, 0 visits to that facility before children were placed there. Very vulnerable, traumatized children sent 2,500 miles away from home. And 0 visits during the certification recertification process, which happens every 2 years and was actually happening during this very time frame. No visits from BCBH, the certifying agency, until after we brought the issues to their attention. That means no certification officer saw children wearing color-coded prison-style jumpsuits. No one certifying this facility saw children sleeping on mattresses in the hallway because there had been a flood that never got remedied. And no certification officer seeing the barbed wire and 24-hour surveillance of this children. Yet it got certified and it got recertified. In addition, one of the biggest concerns we had was the lack of restraint and seclusion reports. A major part of OCA oversight is reviewing restraint and seclusion reports from all facilities where New Hampshire children are, which are required to follow New Hampshire law. But BCBH had decided that only contracted facilities should have to send their restraint and seclusion reports to a central reporting location, which OCA had access to. Certified facilities were not required to do that. And that was a choice that BCBH made and continues to make. So we continue to not have access to restraint and seclusion reports for many facilities where New Hampshire children are because they just have chosen not to contract them. Now, we understand contracting takes time, but an issue here is that this is a choice BCBH is making. There's plenty of certified facilities that have been certified for a lengthy period of time, and they've never even been asked to go through the contracting process. Might they say no if asked? Maybe, but we have no idea. So that's the current process that we go through. As you may know, a contract is a legally binding document. Certification is not. A contract can be enforced. And here in New Hampshire, the purpose of contracting is to lend a level of oversight, transparency, and accountability that goes through governor and council. Certification is a purely internal process controlled by administrative rules that are only in the oversight of the agency. There is no external oversight of the certification process other than OCA. So that's another advantage of contracting, is it does lend this external oversight, and it's a legally binding document. And just one more point, well, to go with that, under New Hampshire law, any services over $10,000 are supposed to go through governor and council under MOP 150. For some reason, these facilities that, as we all know, receive tens of thousands of dollars are exempted from that process somehow. But finally, there's been a recent Supreme Court decision here in New Hampshire that the court itself said, when looking at some DCYF internal policies, that the court doesn't have to adhere to those. Not to policies, not to procedures, and presumably not to administrative rules, because what the court said was, we only look at the statute. The legislature has decided what it wants the court to follow, and they have to put it into law. Otherwise, the Supreme Court doesn't have to follow it. So those are all concerns that we were trying to address by that bill. And as much as it pains me to disagree with your chairperson, Pearson, we strongly disagree that the certification process is adequate, because we've seen that it's not. We've seen that BCBH doesn't even follow its current certification. So I'm not sure why them bulking up those certification processes would make any difference. They are still internal only with no external oversight. So just to take you quickly through the OCA amendment, and I'm sorry, Chair Pearson, I did not catch what the number of that one was.
The amendment is dash 0428H. That's the OCA amendment.
And again, it is largely the same. We did work very closely with DHHS to try and come as close together as we could with language and really with purpose. We all agree we want to protect our children. We just have a slight disagreement of what that's going to take. So Section 1 is a statement of purpose. We do believe that is important, that children have rights, and especially when they are in state care, the state has an obligation to provide appropriate care. We are looking to sort of confine residential placement to ages 12 and over, and on short-term, narrow circumstances only. There are some other bills in the legislature this session around that issue, including SB 417. Section 2 of the original bill was completely deleted because it actually referenced not a correct statutory provision, so that's gone. Section 2 of our amendment, and I believe it's consistent with the DHHS amendment, just has some additional language around the definitions and the monitoring to make it internally consistent. Section 3 is really where a bulk of the differences lay, as Representative Pearson stated. Already, facilities have to be properly licensed. That's a separate section of DHHS that does licensing. All in-state facilities have to be licensed. Foster homes are licensed. Childcare is licensed. Separate process. In addition, BCBH has that certification responsibility and contracting responsibility for facilities they have chosen to contract. Our amendment and what would be new to the law is OCA feels very strongly it's important that all facilities that children are placed in, particularly by the state, whether it's DCYF or BCBH, should also be contracted. We did come up with some compromise language, as we stated, that they be contracted or have at least initiated the process of contracting up to 120 days. Obviously, you all are policymakers, can decide if that's the appropriate amount of time. We do understand contracting takes time. I understand the division's contracting bureau has been recently increased last year's budget. Governor and council does meet twice a month. It is a process, but it's not doable. I would argue that every vendor with the state is actually required to be contracted. We don't do business with people who refuse to sign a contract. But we did try and build some wiggle room in there. We certainly do not want to leave children without a place to go. They should be certified before a child is placed there, and it already says that. We do have concerns about the following the actual current certification process. That really needs to be bulked up. Eyes have to be on. They need to be doing more than simply getting resumes and brochures from facilities. They really need to go investigate and make sure it's safe, even under the current administrative rules. So that's not being done, and we hope that it will be. Part of that is by creating a team within the Bureau. This would require a little bit more staff to really make sure that certification process is being done thoroughly, that they're in-person visits, they're really looking at the program. So we'd also ask that that team create a standard operating procedure form that OCA would be involved with. And just some of the certification requirements are a little bit more specific about what they're looking at. It would also require enhanced monitoring visits. Currently, they are supposed to be visiting contracted and certified facilities every year, 1 year for certification, 1 year for quality assurance. As we understand, that wasn't happening anyway. We would like to see quarterly visits. As you all know, there's a push to really get kids out of residential care. So really, hopefully, this number is going to be going down and down and down anyway. But in the meantime, we want to make sure that someone has their eyes on those children who are in state care to make sure the facility is the most effective placement, an appropriate placement, the least restrictive placement.
I do want to add currently, just so it is very clear, when we're speaking about DHHS, there are two separate entities that are involved with these children typically. We have the Department for Children, Youth, and Families, that is typically the placing agency, and we have the Bureau of Children's Behavioral Health, that is the one that is certifying and overseeing these facilities. DCYF policy stands that they are required to go to these facilities once a month to visit with their children. They need to see all children on their caseloads once a month. There was a caseworker out there every single month in Bledsoe between January and July when the OCA went to visit. Not one of those DCYF caseworkers brought forth the concerns that the OCA found when we went to this facility. So the certification team that is supposed to be looking at the physical facility, the programming that they offer, and the treatment of the children had not been out there. The worker that is responsible for checking in with their child and ensuring that their needs were met were out there. The problem is that we need both. Those DCYF workers are not tasked with doing a full facility site review. That is not their job when they're going out there. Their job is strictly to check in with their child. Are your needs being met? Here are updates on your case. I will see you next month and we will touch base before then. And so there are people going out there, but not the people that are responsible for holding these facilities accountable. And accountability is key. We are not currently seeing much accountability at all for these facilities. I'll share with you, unfortunately, we had to bring forth at the last Oversight Commission for Children's Services meeting that Nashua Children's Home had used illegal prone restraint on children. That was changed in the law last year. That continued. That occurred in January. What is going to be the accountability for this facility? We have not heard yet. We do not have an update that any action is taking to hold them accountable for using illegal restraints. We need more accountability. And so that does have to come from that separate entity. But yes, have there been eyes on the children? Yes, not the correct eyes. Just want to make sure that piece is clarified.
And that was a great segue, because the next section of the bill, section 4, would add 2 new sections to 169F. So 169 is the child serving section of the statute. 169B is juvenile justice. 169C is abuse and neglect, which is where the rest of this bill would go into, or most of this bill. 169D is CHINS, which are children in need of services, a separate section. So 169F is a underused at this point, but not if we have our say, because we would like to put stuff in there. It actually is over the entire family court division. So applies to judges with court-ordered placement under 169B, C, D, and court-ordered treatment, episodes of treatment placement. That'd be BCBH. So 169F is a catch-all to make sure all courts overseeing kids that the state puts somewhere would do these things. So the first section is around those monthly visits that Cassandra was just talking about, which are required and are being done right now, but sometimes can be as short as 15 minutes. Literally just putting their eyes on the kid. You look okay to me. It can often be a different person. Cassandra mentioned there had been 7 workers. That was 7 different workers, none of whom were actually the children's caseworkers. They didn't know these people. 7 different strangers coming to visit for 15 minutes in a little conference room. Those kids did not disclose anything to any of those folks. When the OCA showed up, who did have relationship with these kids, disclosures. So it is important for children when they're being visited to actually know the person, for the person to know something about the child and the family and the case. So the new section would require that the worker visiting is either the child's actual worker, we understand that is not always possible, or at least someone that knows something about the case. Could be that person's supervisor, a former worker, the assessment worker, somebody that knows something about that child and that case, and preferably the same person more than once, so the child can build some rapport. We are also asking for that visit to be bulked up a little bit, not a whole site visit like BCBH does, but take a look around, at least look and see where the kid's sleeping. See where they're eating. If you go to a foster home, a worker would do that. They go look at the kid's room. They'd talk to the other people in the house, look in the kitchen. That's not happening at residential facilities, which makes no sense, because a child who's living in a foster home has teachers, doctors, counselors, other people that see that child. If there were concerns, they could call, raise a red flag. A residential facility, that's the only people that have their eyes on that kid. So to not check out the facility means nobody's seeing, is that kid sleeping on a mattress in the hallway? Is their room stripped of all personal belongings? Is there food in the kitchen? So just a little bit more of a visit. It does not have to be extensive. Also checking in, which is required, but just a little bit broader of, we're checking about the therapeutic culture. We're checking how the kid's doing with their therapist, with the teacher. Things that get done by every DCYF worker, particularly a kid in a foster home, but seem to being missed a little bit, especially children far away. That would also develop a new form with OCA to make sure that consistent record keeping is happening so that the OCA oversight is actually effective. We can't effectively oversee if we can't see what's happening. The last section is aimed at the court oversight of residential placement, which is also essential to protecting these children. Currently, the court just gets the information the division gives. It's not always thorough. The court may not know which placement is most effective for a child. They're really just taking what the division's giving them. So this section bulks up again in 169F so that it does apply to children in juvenile justice, in CHINs, in abuse and neglect, but really delves into what the assessment has to say prior to placement to make sure residential placement's appropriate, what review hearings look like, having them be more frequent, what documentation is provided at that review hearing, both to the court as well as to the parties, to make sure these children are not languishing in a placement that's simply not appropriate to them. You know, we are short on beds, we are short on placements, but a child shouldn't be sent, especially thousands of miles away, and just left there. You're done, we placed you, we're not doing anything else. So this really builds up the framework to let the court do their job, because, you know, we do have separate branches for a reason. Court oversight is essential to protect these children as well. And then finally, there's a new section at the end that got left off of the original bill. This is also important, reallocation of funds. Frankly, in other states that have been trying to bring their children home and get them out of residential placement, this has just been essential to making this work. Reallocating any funds that are recouped from not sending children to these extremely expensive residential placements. And again, this is taxpayer money. Recouping it, but keeping it within the system. It doesn't just go back into general funds. It needs to be then used to bulk up the community-based services, because as we all know, and the new DCY director has talked about, in order to keep kids in their communities, whether it's their home, kin, fictive kin, even foster homes in their communities, you need those intensive wraparound services to make sure that they are safe. So in order to recapture that money that would have gone to residential placement, back into those community services. And if I didn't mention before, another big thing about contracting is simple fiscal responsibility. As mentioned in the Bledsoe report, we spend a lot of money putting these kids in placements that are potentially harming them. And we are responsible to the taxpayers in that process of contracting. To have that executive council oversight, which is what it was created for, is really important for fiscal responsibility as well as the safety of our children. That was a lot of information, but we're here to answer questions.
Thank you. We're open to questions.
Okay, great. Thank you. Any questions? I do have, with respect to contracts and certification. In a certification, can you require that certification to follow restraint laws in New Hampshire?
It can. Our worry is the accountability piece. With a contract, you have a legally binding document. And so if they're not upholding that, then there is the opportunity to hold them accountable to that. We have believed all along that whether certified or contracted, all residential reporting should come centrally, should be overseen. That still has not happened. And that has been an ask of the Office of the Child Advocate from before I joined the office. So I would guess from the inception of the office, that has been an ask.
Okay, and follow up the contract, I would suspect you could breach the contract. However, what do you do in an emergency when you're breaching a contract and you're pulling, like the two children that we pulled from Bledsoe? Wouldn't that create more of an emergency?
Even current contracting and certification process, both, and it's actually within the bill as well, there are corrective action plans. I mean, usually in any contract, the first breach is not immediate cancellation of that contract. You usually do a corrective action plan that is built into the statutes already, but could be easier to enforce with an actual contract, as well as you then have that outside agency, governor and council, that could be, you know, pushing that there's not been enough corrective action. But frankly, it's a problem now, even with certified and contracted facilities. Cassandra mentioned NCH, constant violations, not just of the contract, but of children's rights in abuse, then is nothing's being done. And part of that's licensing. It is a complex issue. There are multiple factors, but absolutely it should be enforceable, but it doesn't necessarily mean we're shutting you down. Could just be corrective action.
Okay, and with respect to the reallocation of monies, does that stay, for example, the Bureau of Children Behavioral Health, that funding will stay to them, and DCYF funding will stay with them, or does it go to DHHS for reallocation?
The way in which it is written, it is broad for that purpose. I ideally, in the conversations that we've had with the agency, which they did not argue this point, is to agree that if a child is coming from a residential facility and requires more intensive services, the funds that would have been going into the residential facility should follow that specific child into their community services. So that could be a service that is better fit for them that's offered through DCYF, or it could be a community-based service through BCBH. So that's why it's left more broadly so that DHHS can put the funds wherever that specific child needs them.
And we know the agency is working really hard to kind of break down those silos. You know, we have meetings monthly with Jeff and Katja and BCBH and Krista and Marissa. They're working really hard to make sure that the children's system of care, the way it's being built out, is accessible. Obviously, there are still barriers. There's still a lack of services, but we have faith that they have that in mind, that they want services to be available, and they will get creative to make it work.
Great. Any further questions, Representative Gibbons?
Thank you, Mr. Chairman. Could you provide context? How full, as far as capacity, are these residential facilities? So in other words, if one was to be shut down and the kids were moved into different facilities, would other facilities be able to absorb them, or would we be in some type of crisis with where to place them?
We are definitely in a placement crisis already. And one of the major issues is staffing. Some of the facilities do not have the ability to fill all of their beds because they do not have adequate staffing right now. And so this is where our children who are higher need end up being sent out of state, because the programs in state have more children to pick from. And they may pick a child who doesn't have aggressive behaviors versus one that does. And then the one that does is the child that's sent out of state. But we also know that there are many children lingering in residential care that do not need that level of care. They should be in foster homes. They should be with fictive kin. And so that is our constant push on the agency as well, is moving these children along. And in some of the language in this bill assists with that, where it's really focusing on what is residential treatment. It is a short-term episode of treatment to then return to a community setting for a continued outpatient level treatment.
And again, it's not necessarily the goal of us, sorry, I can't see you while speaking to the microphone, of either the OCA or the agency or this bill to shut places down. Yes, Bledsoe needed to be, frankly, they haven't been shut down. We're just not sending children there anymore because that was really a dangerous, inappropriate placement. But we hope that this enhancement of the review, the oversight, the interaction will help facilities raise their standards by force, if necessary, to be appropriate for our children. We do not want our children in unsafe, ineffective, inappropriate placements.
What type of staff are overseeing these kids in these facilities? Are they like LNAs? Are they nurses? Like, what type of, do they have their own licenses?
The direct care staff, which are the ones that work specifically with the children, they're the ones that do their evening routine, get them to bed, their regular schedule. They are not paid very well. There's not high degree requirements for that job, but we do understand that the pay is really what is losing a lot of folks in that field, because they are able to go to, say, a fast food restaurant and make more money there and have less stress than working with kids with high needs. But they're not high level positions to fill. They do have clinical positions on staff, but they're not the ones that are in the milieu with the children. They are doing an hour a week of therapy, maybe two if they're doing an hour of family therapy, an hour of individual therapy. So it is primarily those direct care staff. And so when we're going into facilities and we're assessing and seeing a concern, we're really focusing on what education may they need, because they don't have high education requirements to fulfill the job. So what trainings can be brought in to help the staff lead more trauma-informed practices? What kind of consultants can come into the facility and help shift the culture in the overall facility? So there's a lot of work that can be done, as Alyssa mentioned before, getting to the point of either canceling a contract or decertifying a facility.
Okay, thank you.
Thank you, Mr. Chairman, and thank you for taking my question. I have two things, and the first one is I wondered if you had any more copies of the report, because we are short 5 on this end of the table. And the second is regarding training for staff who will be doing these visits, both through the quarterly visits and the annual unannounced, but for the monthly visits for the DCYF worker, hopefully someone who knows the child, but even if it is, the rotating group of workers that it has been, what kind of training would become available? Because if we now are mandating that they do specific things, which is, in my opinion, entirely appropriate, is there a training that will teach them how to notice these signs so that these things don't fall through the cracks again?
So one of the reasons why we added a form in creation with the OCA is to give them a guide when they're out at these facilities. Oftentimes there's so much going on when you walk into a residential facility and you're there on a mission to see your child, make sure they're okay, and then get to the next visit because, as you know, the days are so busy doing this work. And so the form is really just the guide because they already are trained to look for these things when they're going through the regular DCYF training. They're looking for them, as Lisa mentioned, in foster homes. They already have that eye. It's when there's so much in front of them, having that guide telling them first, you're going to go look at the child's bedroom and you're going to report what you saw in the bedroom. Then you're going to sit down and talk with the child and ask them about their experience, ask them about therapy, ask them about schooling, right? And giving them a guide for every topic to discuss so that they're not missing something should be the piece that ties back into all of the training that they already received in their initial social work training and the additional trainings that they are offered through the agency. And we would like to be a part of that because we are doing those site visits. And that is something that DHHS has been open to, is to allowing us, one, to work on things like a form like this, or even to come in and present to their staff how we operate in our site visits.
Thank you.
I would just like to add, the workers at DCYF, I worked at DCYF, the folks at BCBH, they are well-trained folks. A lot of them have a lot of experience. It's not that these are all new things they're looking for. Frankly, this is really what they have been or should have been looking for all along. But by spelling it out in statute, it makes it clear, it makes it more enforceable. But these are the types of things they would be looking for. It just hasn't been written in law that this is what you need to take the time to look at the room, to see the environment. So I don't know that this is all new stuff, like they haven't been doing any of this, but because of what we saw at Bledsoe, we just want to make it crystal clear in the law that it is the policy and the law of the state that they do this.
Follow up? I'm just going to ask it. Thanks. So regarding, are there any circumstances where we're finding that the workers are being denied access to like the rooms where the children are staying? I'm trying to recall, I worked for DCYF years ago here in New York as well. And frequently when you visit a child in a residential placement, there's like a visitation room, right? As opposed to going to that child's actual bedroom where they're staying. Have we had any trouble with people accessing those rooms? And do we think that spelling it out in statute would be helpful?
We have not heard any difficulties with accessing the room. We always ask to see where children stay, and we've never been denied either. They have the same access to children as the OCA would have, and so there should not be any denial of allowing them into all different areas of the facility.
Thank you.
Thank you.
Thank you, Mr. Chairman. And Ms. Sanchez and its Attorney Matthew? Pardon me, Attorney Massio. Specific to comments that you made that when visits have been made to the subject property, as I'll call it, that it was found they were not following, quote, rules. When they're out of state, what sense or guarantee would we have they would follow our rules when they're the authority having jurisdiction?
So they do have their own licensing entity. And so our state, through the certification process, is required to touch base with their licensing entity, ensure that they do have an active license in place. So they do have that. They also have their own child welfare system who does the oversight. If there's any concerns of abuse or neglect, they're called into their facility, which was part of this process. We did call in abuse and neglect to their child welfare agency. So although they have their own entities, we are the one that are placing the children there. Our state of New Hampshire is placing the children there. the state of New Hampshire is funding the beds that those children are staying in. And so this brings it back again to the importance of a contract. In a contract, you're saying you provide X, Y, and Z service to our children, we provide you this funding. And then if they're not meeting the services that they agreed to pay for, you're saying you're not meeting the contract, and we have an ability to hold you to that because we have in writing that you're going to provide this, and we know you're not. But that is what the importance of more regular in-person visits, because it's very difficult to be alerted of these things when it is out of state. And if the state isn't there on a regular basis, are they truly catching them? Or is it going to be a year later after they were certified and they're going back out to see the facility? So the quarterly visits would also show a presence there. And we have heard from some residential facilities, I heard Vermont is one actually, that Vermont goes out monthly with their folks that do the certification process. And so facilities know when the state of Vermont is coming, and they know that they need to have everything in order because they are going to be there on a regular basis. So that presence is critical to hold them accountable to what they're telling us they're going to provide our children.
And folks that take New Hampshire children, whether it's contracting or certification, are required to follow New Hampshire law as it relates to those children, particularly 126U, which is in the contract and in the certification rules, that they must follow our 126U because those are our kids paid for our money. But again, there's been a lot of instances, as we discussed, NCH, even right here in New Hampshire, that simply aren't following the rules. So it's that next piece of accountability, oversight, and enforcement of you're not following those rules. Being able to get the restraint and seclusion reports to a centralized area, which is not currently happening with certified facilities like Bledsoe, would also have additional oversight by BCBH certification, by the OCA. So they are required to follow New Hampshire laws as it relates to New Hampshire children, but it's whether or not we catch them. So that's where the additional accountability is required.
One follow-up, Mr. Chairman.
Follow up, sure.
Specific to, Attorney, to your comment just then on the Bledsoe being, quote, certified, so-called. If they're not performing to the certification, and then we have our representative or representatives visiting, why are they not terminated immediately since our children are being held hostage, in my view?
That was
Thank you, Your Honor.
I'm not the attorney, but I will take that question. That was a question that we came back with. That was our question, is if we saw something so egregious as this, why were the children not immediately removed as an emergency and brought back to safety in New Hampshire?
Right.
It did not occur swiftly. It took a month to get the children back. It took at least an additional month from the time the children returned to decertify the program. And that for us is too long and too much of an opportunity for our children to be in harm's way.
Is 100% of our clients out of Bledsoe now?
Yes, and they are officially decertified at this time.
And during
Yes.
that period, though, there was another child being considered to be sent there. So it needs to be a fast process because, if the left
Right.
hand's not talking to the right hand. But, the contracting piece of that does give that extra level, but it doesn't always have to be cancellation of contract. That, in a contract, you can build in provisions for oversight and, enforcement.
Understood. Thank you, Mr. Chairman.
You bet. Further questions, Representative Grossman?
Thank you, Mr. Chairman, and thank you to the Office of Child Advocate for all the work you do and for bringing this forward. So we're talking about out-of-state residential treatment right now. For our in-state treatment, are we certifying or contracting?
So in-state, we have both. So all facilities are certified. In-state, we have a number of facilities that are also contracted. The priority of DHHS was to first contract in-state facilities, then to work in the New England region. So there are a number of facilities in the state of Massachusetts, possibly Vermont and Maine as well, that are also contracted. We have asked how the order of preference was determined, what the next preference would be for additional contracts, and have not been able to get a clear answer on that question. But from when I first joined the office and was learning about the Bureau of Children's Behavioral Health process and the contracting that they were undergoing at that time, was told that the intention was to continue to expand contracts to more facilities over time. We have not seen that change occur yet.
Follow up?
Is the Nashua Children's Home contracted or certified?
They are both.
Thank you.
Representative DeSimone?
Thank you, Mr. Chair. I'd like to go back for a minute and get some real numbers here, if that's okay.
Yes.
Thank you so much for taking my question and all that you do.
Thank you.
How many children on a regular basis annually are placed out of state? Approximate.
So those numbers have reduced greatly since our Bledsoe report, and so we've been tracking them very closely since that time frame.
Yeah.
They are. I brought my recent data report with me, and so we have. So typically, there's around 300 to 350 children placed in residential care overall, and out of those, primarily they're in New Hampshire. Currently, as of the last data point that we had, there were 81 in the New England region. The New England region has always been very high, and there are down to 4 nationally. When we first began looking at this issue, there were about 20 that were national, and there had been times in the past that they were higher than that.
Thank you. How many facilities do we use on a regular basis to place these children in between New England, Bledsoe, and wherever else?
We have a large number of facilities. That number is changing because there's additional ones are added and taken out quite frequently. My understanding is there are 44 that are contracted facilities, and there are approximately additional 42 or so that are not.
And those are out of state.
There may be 1 or 2 that are in state, but they're primarily out of state.
Okay. One more, please.
Follow-up? Sure.
Thank you. And how many inspectors do we have employed in the state of New Hampshire for these facilities?
I can't speak to the licensing inspectors, but I can speak to the BCBH certification team. And currently that team is a team of 3. And we understand that is why they're asking for additional positions with this bill to be able to bulk up that team for travel purposes.
To how many?
Go ahead.
To how many?
It has changed. And they're here.
Yes, I would reserve that question for them because I do believe we saw a different number in the recent fiscal
Okay, sure. One final.
note.
Final? Sure.
Thank you. I know I said one more, but I lied. Have you been given a reason why it took a month to get those kids out of that place?
Not a reason in which we could understand.
Thank you very much for your time.
Thank
Any
you.
further questions? Seeing none? Thank you.
Thank you.
Now I have 2 cards here, both DHHS. Do you need to speak separately, Miss? Okay, so could I call all 6 of you forward? Okay. And then I have another card for Mr. Moore, Keisha, Jeff. Is that another? Okay, great. Okay. Go ahead, Ms. Hen.
Good morning. My name is Marissa Henn. I'm the Deputy Commissioner at the Department for Health and Human Services. And here today, of course, to provide information on HB 1573 relative to the oversight and criteria for residential placement of children. I want to start just by thanking Representative Pearson and the other sponsors for their commitment that we share to prioritizing the well-being and safety of children and allowing us to provide information about how we remain committed to working on that mission. I also want to thank the Office of the Child Advocate, who you've just heard from at length. We have been deeply involved in collaboration for many months as we work together to strengthen the residential treatment system and the children's behavioral health system of care as a whole. The OCA deserves great credit for their work, bringing this issue to the fore and engaging with us as partners in pursuit of our common goal to support youth and families. And I have to say, I will pause. One of the things I've always appreciated about Representative Pearson, the primary sponsor of this bill, is his ability to bring thoughtful people together on issues of common ground. And one of the things that struck me as I was listening to the OCA's testimony is how unfortunate it is that when we agree on 99% of what is in a bill like this, that at times the impression that we are conveying to you all is that we are in disagreement, that there are lack of protections, that we don't trust one another, that we don't believe in the common goal that we hold dear. That could not be more far from the truth. And the allegations and some of the falsehoods that were just made around the lack of protections, the harms occurring to kids, the nature of contracting, the legal basis for contracting, there's so much to unpack there. And to me, it suggests that I have a tall task ahead of me in terms of unpacking that for you all and actually correcting the record, but also that we have a lot more work to do to help educate the Office of the Child Advocate in terms of how our system actually works, in terms of the protections and how we are advancing that common goal. And so I would just urge you to listen to what I have to share, recognizing that if you simply listen to what was just shared, you would think that we're actually in opposition to this bill when there could be nothing further from the truth. We at DHHS are deeply grateful for the work of the OCA, Representative Pearson, and all of you for considering these important reforms. There is basically one technical detail that we want to urge you to reconsider in the interest of best serving the children of New Hampshire. So I just want to preface with that I hope to take the high road here in terms of emphasizing collaboration. My plan was not to re-adjudicate and re-educate around what happened relative to Bledsoe. I am more than happy to do that at the end in terms of answering the myriad questions about the decisive action we took to keep kids safe, the way we collaborated with the OCA and many other partners across the state to get kids from that outlier program home safe. But let's stick with this bill for the moment, and I can answer your questions as they arise. So essentially, as I said, 99% of this bill we completely agree with. We think that this is a step forward in terms of our ability to keep kids safe when they do require this level of episodic care in a specialized residential program. There is one thing that we disagree with that in the amendments as Representative Pearson introduced. And essentially that one thing is the requirement that all residential programs be contracted. And I want to just carefully explain why requiring contracts for all programs will be a step backward for New Hampshire youth and the systems we're building to serve them. So first, contracting is not what ensures safety and quality in New Hampshire. Certification is how that is achieved. Certification is what sets a very high bar that has only grown higher in recent months as we collaborate with the OCA, with advocates, with many legislators to strengthen our system and ensure the accountability to keep kids safe. We have a robust certification and licensing process, whether the program is contracted or not. So let me be clear, all programs must be certified, whether they are contracted or not. So contracts are really primarily a financial mechanism that we use for the programs we rely on the most. So programs that are in New Hampshire or in our neighboring states are contracted. There's 21 contracts. We've been bringing forward a number of enhancements to rates to help ensure that the availability, the access, the quality of those programs is as high as possible. Contracting takes a lot of time. It involves significant negotiations. And so it's right for the vast majority of programs. And I think that's what was lost in the testimony you just heard. For 99%, and I'm not exaggerating, literally 99%, all but 4 kids as of today served in our residential treatment program. They are in contracted programs here in New Hampshire or in New England. And so again, this is the norm. What we are talking about is that occasionally for 1%, so currently representing 4 children from the state of New Hampshire, we have youth who have a very specialized level of need for which a contracted program does not exist. And if a youth needs a program that does not exist through contract, we need to do everything we can working with their parents, working with caseworkers who serve them, working with agencies to engage in a nationwide search to find a program that can serve them. We utilize a clinically based assessment process that individualizes these placement decisions. And so I just want to emphasize a very small number, 4 today, out of roughly 400 who are being served, we have to look for these specialized programs, and we leave no rock unturned. I wish that New Hampshire and our New England states could provide this, but the truth is some kids have really special needs. And I'll give an example without, again, we have to just putting together kind of common cases that I learn about. Let's say that we have a girl with reactive attachment disorder. It turns out that RAD, reactive attachment disorder, doesn't have any providers in New England or New Hampshire included that we can contract with. There are programs outside of our region. So for that young lady and for her family and others who are desperately seeking to get her that specialized care, we need to be able to accommodate the occasional one-off programs. And it's not like we just send a girl like that to a program and say good luck. We engage in a deep and robust process of certification. Again, certification is the key word here to ensure her quality and safety. So I'll actually hold up. There's a 48-page guide to all the requirements for certification. This is not a light process. This is not a process we take lightly. Our program visits the program initially. We engage in an in-depth tour. We interview their clinical staff. We ensure, per your thoughtful question, that they meet all of the requirements, the training, the certification. We complete file reviews. So we randomly select files to ensure that the quality of treatment, the therapeutic modalities that are utilized are meeting our expectations for the state of New Hampshire. We analyze how they assess youth and engage in treatment planning. We review their daily notes. We review their clinical notes, how they do discharge, incident reports, reports of restraint and seclusion. Again, for the OCA to say that we are sort of willy-nilly sending kids into programs, that it could not be further from the truth. There's also an in-depth set of documents that we go through, looking to see if they are in good standing with the state in which this program is located. So we look for other reports of what could be occurring there. We look to ensure that they're in compliance with all the licensing requirements in their home state. And we don't just stop there. We also engage in annual visits, as well as a combination of technical assistance visits to help them improve their performance. Youth from DCYF, who are largely those who are served in these programs, are visited every month. And again, just to correct the record, these are not 15-minute visits where we pick up some pamphlets, as you just heard. These are in-depth visits. We take them extremely seriously. We check on the youth under our care. We interview them. We have a critical responsibility, serving often in the role of parents and in our obligations as a department. And so it gives me goosebumps to imagine the notion that we would do anything but the most robust protections. And beyond that, we don't even just do this initial and these milestone annual visits. We also have numerous protections should anything concerning arise in the meantime. So any concerns around potential abuse or neglect, we have an entire special investigations unit within DCYF who investigates institutional abuse. We work with the Department of Justice. We work with the Office of the Ombudsman. Within DHHS, we have child care licensing. We have the Bureau for Children's Behavioral Health. And under our leadership in the Commissioner's Office, we engage these groups together to identify kids who may be in a situation where we need to take urgent action. That's exactly what happened with Bledsoe. And once that case was risen, we took that action. So safety requirements and safety violations are all part of that certification. It's it's not a one-time process. It's ongoing. It ensures that youth are safe. As it pertains to the placement of youth, contracts are largely a mechanism for payment. To think that there's something magical about contracts, the truth is contracts have to be monitored. They have to be enforced. Guess who's responsible for doing that? Not a third party, DHHS. So to think that there's something about contracting that is advantageous is just simply untrue. So I want to emphasize again that certification is required of all residential programs serving New Hampshire youth. It is a high bar. And once they engage in this process, it's been considered so rigorous that some providers decide that they don't even want to be certified, in which case we would never send a youth to such a program. No child would ever be sent to a program that is not certified, and this has nothing to do with whether they are contracted or not. The second point I want to make, beyond clarifying that this is about certification and not the financial mechanism of contracting, as well as the point that this is 1% of the youth that we're talking about, is that if we require contracts for that 1% of cases, we are going to actually cause harm to youth. So take, for example, a child with a serious emotional disturbance and a co-occurring developmental disability or medical fragility whose issues and needs have escalated, and the family is at their wit's end. Perhaps they're even sitting in the windowless room of an emergency department, waiting as their insurance company, as caseworkers, as our DHHS teams search for the right program. This is what's happening. If we have to wait for governor and council to meet once a month, that's an additional series of weeks of waiting for that child with specialized needs to get into the program that he or she deserves. We are not looking to sidestep responsibilities or legal protections for anyone. We're trying to navigate complicated bureaucratic processes to get families what they need quickly. I believe we've distributed to you a flow chart that describes our contracting process. If anyone would like to reform our contracting process, you are more than welcome. But let's just say New Hampshire has made it, for good reason, very complicated and long. Each one of the steps in that flow chart takes 3 to 4 weeks on average. I won't bore you by going through every step. It requires reviews by the Attorney General. It requires reviews by the Department of Administrative Services. There's a reason why in the live free or die state, things move a little more slowly in government, and we have this entity called governor and council. So I'm not complaining about the process. I'm just observing that if we want to get that 1% of kids into a specialized placement, we cannot rely upon this bureaucratically heavy, slow system, or we are going to have kids languishing in the wrong places. A sole source contract, which is what we're talking about, would take on average about 120 days to complete. So that's 120 days, an unacceptable amount of time for a child to be waiting and waiting when they are in crisis. And so we need that flexibility and efficiency to occasionally engage in a process to get that kid into the most appropriate level of care, and then ensure all those enforcement and protection mechanisms that I went through before are in place to ensure that their safety and well-being is always the priority. I also want to mention that if we were to require contracting for that additional 1%, since we already have it for the 99%, it could really negatively impact other parts of our system. So for example, right now, if a child needed our highest level of care, at level 5, which is a psychiatric residential treatment facility, but they're currently in a level 3, that is basically going to create an issue of bottlenecking in the system where they can't move because they can't get space due to the child who's waiting for their seat. So essentially, you're not just impacting that one child who's going to be sitting in an emergency department or in another desperate situation waiting to get into care. You're also bottlenecking the entire process for youth who may need to move between levels as their therapeutic needs change. And so, again, I just want to say that we recognize what the OCA is trying to do. We agree with probably 99.9% of it as reflected in this very thoughtful bill they have helped craft. Simply having to go through governor and council and a contracting process does not add value here. It will do harm. And to think that contracts offer something magical, or that the claim that certification is not legally binding, is completely untrue. The courts have found that rules and the process of certification very much is legally binding. And so this could really have harms to our youth. And again, I'll just close by saying that, I began by saying that we want to be collaborative here. We want to be open. We want to be transparent. We want to avoid kids needing residential care whenever possible, keep them in a home-like setting, wrap supports around their families, around their communities to keep them well and to keep them thriving. In those rare times that a youth needs residential treatment, we need to ensure that those programs are top quality, that they're meeting New Hampshire's high standards, and that there are protections in place so that if something is occurring that should not, that we ensure those kids are moved to a more appropriate and safe location. We are committed to working with the OCA actively to move this work forward. If we require contracting for every certified program, again, this would affect 4 out of 400 kids. It is going to be a major step backward. It's going to add time. It's going to add bureaucracy. And frankly, just as Lissa said, we want to avoid having kids languishing in inappropriate care. We could not agree more. That's the very reason why we ask you to advance the amendment in which we have asked for the flexibility for this very small number of youth to be able to serve them, to reassure their families we can get them care in an appropriate place and that we will keep them safe. We believe that our amendment supports that mission. Thanks so much for the opportunity to provide feedback, and both myself and our team are happy to answer any questions.
Great. Any questions? Representative Raymond?
Thank you, Mr. Chairman, and thank you for taking my question. So my question is on the process of contracting. So the amendment offered by the Office of the Child Advocate asks on page 2, line 13 and 14, it says, and contracted by the department, or at least have initiated the process of contracting to be completed as expediently as possible. So as I'm reading that, not being an attorney, it sounds to me like if there is a child who needs, for example, a level 5 placement, that a child could be placed there as long as we have initiated the contracting process with that placement. Am I misreading that? Because it sounds to me like the child could be placed there while the contract is being negotiated.
Yeah, I'm going to call up Rebecca Ross, who's an attorney by training and also the director of the Bureau for Children's Behavioral Health, to answer that thoughtful question.
Thank you.
Morning. For the record, Rebecca Ross, the Director of the Bureau for Children's Behavioral Health. If I understand your question correctly, you're asking if the bill represents that all we would have to do is begin the contracting process in order to place a youth. Is that correct?
Yes, my question is so that there would not necessarily be that bottleneck. But then I guess to further the question is, you now have 6 months to get that contracting process banged out before you have to make a decision on whether or not the contract is not going to happen and a different placement would have to happen.
Right. So the problem with that process is that the purpose of the contract is to have a meeting of the minds on what they're going to provide and what we are going to pay. If they start performing under that contract, they will be expecting payment. If GNC has to approve it, GNC may disagree, and then New Hampshire's in the position where another provider has detrimentally relied upon our representation that we would contract with them. The decision makers have chosen not to, and we still owe them the money. So in order to be in a place where we have a binding contract that represents what we're actually agreeing to, we need to do that before they're providing the service. This sets up a framework where we're constantly in the place that we have to agree to whatever terms that a provider is offering, because we have to enter a contract because they're already serving a youth.
Follow up, if I may. Thank you. So because this is the crux of the difference between both of your bills, because you both require, extensive visits and follow-ups, and I love that about both of them. So for your bill, in that same situation, we have a child who needs a higher level placement. You would place them with the under a certification process, right? Without doing a contract. Would we not still be required to pay for the service? And I mean, I guess my question is, what's the difference to the child that we're talking about between creating a contract that could maybe be used for other children or not creating a contract? Like, what's the difference for the service provision and our ability to make sure that the kid is getting appropriate services in a safe way?
Practically speaking, for a single individual going to an out-of-state provider, none. The history behind the contracts more relates to system-wide change and transformation to create a network of providers that meet all of New Hampshire's youth's needs. But for a single child, if we're certifying a program, we're taking them as they are at that time, agreeing they're able to provide the service for that youth, and doing it under our certified rules and paying an established rate.
Thank you.
Further questions? Representative McMahon?
Thank you, Mr. Chairman. For Ms. Ross, or Director Ross,
Either works.
want to address you correctly. Specific to what was offered by your colleague next to you is that we have a certification certification for qualification to provide services to our youth. And then once we have that certification for the purposes delineated that are provided at that source, a contract would be for a specialized application within those services. Would that be a correct interpretation of the process?
I'm not sure I'm completely following. Yes, a contract would be above and beyond any of the certification requirements. So the contracts require that they are licensed within their own jurisdiction, certified for payment by BCBH, comply with the Medicaid rules and certification standards, and then a contract would be on top of that.
Follow up, Mr. Chairman.
Follow up, sure.
Thank you, sir. And in the interest of the timing for the services, as stated by you ladies, in the critical mass that we're dealing with, is that we have to get it done while we're young here, and when we're doing it, is if the certifications are being met, there's a wording here I think is wrong. It says, but in no less than 120 days. We want no more than 120 days, I would think, in terms of signing a contract for specific services. And would that meet I'm trying to read these amendments as fast as possible here. Is that what you're, not that, would you be in agreement with that it would be 120 days or less for any special application to meet the service required by our New Hampshire youth?
Well, I think that's the OCA's proposal, so I would let them speak to what their intent was, but we believe the certification process meets that need, and we would not be proposing to do it within that 120 days.
Mr. Chairman?
Follow up, sure.
When you said would not, you would not do it within 120 days? Is that what you just said?
We're not proposing to do it within any time frame because we believe the certification process is sufficient for the programs that we're using for single youth. But the OCA would be the best party to speak to their intent with that 120 days.
And just to get you one more time, Mr. Chairman, please.
Sure.
Therefore, then the contract would be moot in terms of application of the process, whereas the certification has already set the standard.
Correct.
All right, thank you. Thank you very much. Thank you, Mr. Chairman.
Representative Gregg?
Thank you, Mr. Chairman. And thank you for being here and explaining the situation and taking the questions. How many facilities are you placing children with at this current time that you're not that do not have a contract with you?
So we have a little over 44 programs that are contracted. Some of those are provided by the same entity. So we have less contracts than we have programs because they provide different services. We have a little under 100 certified providers, so roughly half. But as Deputy Commissioner Henn stated, the majority of the youth we're serving are in our contracted programs. We do have 4 youth that are outside of New England in non-contracted programs, and then another handful or so that are in New England programs that do not have contracts. Because when we started the contracting process, we went out to bid, and we entered into contracts with the individuals that put bids in that wanted to do business with us. When those didn't meet the needs, we continued to use some of our other regular partners to meet the needs of the remainder of the youth.
Okay, follow up. Yes, thank you. Now, it's actually kind of a separate question, but you outlined like how careful you are and that you have this process where people go check and, you know, that you have more than a 15-minute visit. That doesn't explain Bledsoe to me.
if you have all of these safeguards and you have all of these things that you're already doing, how did that happen?
So again, I think the purpose of this hearing today is not necessarily to re-adjudicate Bledsoe. What I will say is that we took the OCA's concerns extremely seriously. We'd seen the youth just a couple weeks before, had not observed the same conditions. The youth did not report them to us in the same way that they were observed. And so we immediately initiated an investigation. And I want to emphasize that while to an outsider it may sound like 3 or 4 weeks is a long time, part of what we were trying to do is the whole reason, again, these youth were out of the region is because there weren't services that met their needs here in New England. A transition to a new program is inherently traumatic in and of itself for youth who have been shuttled between programs and foster homes, perhaps for their entire lives. And so we needed to make sure that we had a safe place for them to return to and balance the risks as we worked with Tennessee authorities and the OCA to ensure there was, there was safe plans of care in the meantime. So again, I think rather than re-adjudicate that entire situation, what I will say is we feel confident that thanks to the OCA raising the alarm and our ability to mobilize teams to get down there and to build on what had been previously observed and reported to us, we were able to work collaboratively with Tennessee authorities and with our own teams here in New Hampshire to get the youth back to safe places. So I don't, while I think Bledsoe was a terrible situation, I'm so grateful that the state was able to return those youth safely. I also don't know that focusing on the one outlier, while we need to be prepared in the event that something like that were to happen again, I think we need to recognize also that many of the programs that we certify are very high quality and have changed lives for the better, as many youth and families would attest.
Further questions? Representative Perez?
Thank you, Mr. Chair, for allowing me, and thank you for taking my question. Can I ask you again, did you just say that 3 weeks, it seems like a long time, but it's not a long time for children to go through this process? I just kind of wanted
Yeah.
understand.
No, I mean, time horizons are tricky. I mean, is just as sitting in a windowless emergency room as a child who's boarding in the emergency department is 3 weeks is too long. We would argue that we need to take decisive action also in situations when risks are presented. So, we feel confident that we got those youth back safely, that we designed plans of care so that they were returned safely, returned as promptly as was necessary. We are constantly, is everything in the residential system and in those emergency situations perfect? Absolutely not. That's why we've been working both before the Bledsoe incident and subsequently to analyze everything that's gone on and how we can improve. And I would state again that that's why these sometimes more than monthly, it felt like for a while, weekly meetings with the Office of the Child Advocate to get their input on our improvement, as well as our ability to coordinate so that when they make a visit or when the DCYF team makes a visit or when the BCBH team makes a visit, we're exchanging information so that in the future, regardless of how we want to judge 3 or 4 weeks, that we're able to be even tighter with our process to coordinate and ensure kids are safe.
Thank you, Mr. Chairman, for allowing me to have this question, and thank you for taking my question. Before these children were sent to Bledsoe, was anybody sent to the facility to check out the facility to see how it was operational and interview any of the children that were already living there?
So at that time, we were still operating, as were most states, under COVID era protocols that allowed virtual visits in place of in-person visits. Obviously, that has now changed. And again, I want to emphasize that for those particularly vulnerable DCYF affiliated youth who have experienced abuse and neglect and many other adversities in their life, we're still making monthly visits for those youth, even during COVID.
So during the COVID, thank you. Follow up. So even during the COVID times, people were able to visit facilities by wearing masks if they, to protect themselves. So I don't understand why nobody visited the facility beforehand.
So during COVID, we did things like virtual tours and virtual visits with clinicians for the certification process. With regard to individual youth, they were accompanied by DCYF staff, and that those staff were responsible for looking at the facilities when they arrived with the youth and ensuring they were leaving them in a safe environment. So there were eyes on the facility by DHHS staff when youth were arriving at the facility.
Follow up, sure.
I don't want to compare this to looking for a home, but if you look at an MLS listing and you're looking through the pictures and then you go to the house to look at the house, it looks totally different than what a virtual
Is there
tour
a
looks
question in
like.
there somewhere?
Right. So I don't understand the reasoning to not, other than COVID, what was the justification to just rely on a virtual tour as being a sufficient way to judge a facility?
So I think knowing the history and the context around certification and it moving to the Division of Behavioral Health is important. Prior to a few years ago and right before the pandemic, the Bureau for Children's Behavioral Health did not exist. All of these functions existed within DCYF, and that was the regular practice that the DCYF workers would be doing that work as they went down there. In order to enhance the oversight of residential treatment and move our system forward, we now have a residential unit within the Bureau for Children's Behavioral Health that has taken on those functions. But that really was the norm previously, that DCYF, in partnership with the DCYF workers that did certification, were the individuals responsible for those on-site visits when we were using new providers. Additionally, we do confer with our neighboring states and the licensing entity in the home state to talk to the people who have been on-site and put eyes on the facility.
It's also worth noting, even prior to COVID, visits by DCYF were occurring quarterly. We increased that to monthly. And again, now that it's in a strange way, the world has gotten in some ways so back to normal that even certain things, I think of relatives who passed away, who we had to say goodbye to over iPads. There were realities during COVID that were very different. And we are grateful that we're now back to a place where those who are most vulnerable among us are absolutely need to be seen with eyes on. So we share your concern in that regard.
Thank you.
Representative DeSimone?
Thank you, Mr. Chair, and thank you for taking my question. You said it can take up to 120 days to get a contract signed.
How do you want to?
Is that in the ballpark?
I think that's best case.
Thank you.
Yeah.
Follow up?
Follow up, sure.
Thank you, Mr. Chairman. Thank you for taking a follow-up. How long does it take to certify?
So certification is entirely voluntary. It's up to the engagement of the provider. If it's a company that we've done business with before, or someone that has a very efficient business office, we can get them through the certification process in less than a month, including booking travel to another facility. I have Paulette Rowell, who does the certification visits for us, with me today. On Monday, she's going down to Virginia to do the last step in looking at a new facility for a youth who we cannot meet the needs anywhere else. So we can do it under a month if they are able to get us all of their business documentation, their insurance documentation, their licensing documentation. A lot of it is the going back and forth to say you didn't get what we need under the rules, and walking them through and really helping support them. And some of the programs really need a lot of support, and other programs are very quick to respond and provide all of it. But we'll process it as soon as we have everything.
Thank you. One more.
Sure.
Thank you, Mr. Chairman. One more question, please. You stated that you do monthly visits. Now, in my question to you is, do you notify these facilities that you're coming, or are they spot surprise visits?
So it can be a mix of both. And in fact, even in the Bledsoe situation, once the issue had risen to my level in the commissioner's office, I actually did order that a team be assembled to do an unannounced visit. It turned out we ended up picking up the kids even sooner. So there wasn't that step did not occur because we made the ultimate decision that we just needed to get them. But that was an example of where we have the authority to do unannounced visits at any time. And we do that locally too as part of our performance improvement process.
Thank you kindly.
Further questions? I have Representative Gibbons.
Thank you, Mr. Chairman. Just another question about the contracting process. The takeaway that and maybe please correct me if I'm wrong. This is the basis of my question. Is it that a certification is more for like a standardized care plan and contracting is for like a specific individual who just needs, a very tailored care plan, or is that not the case?
I'll take a first stab at that. So I would think of contracting as sort of like when you're building a system of programs that you rely on. Again, I want to emphasize that for 99% of our programs, they're going through a contracted entity that we work with closely. We know these these are 99% of the kids served in residential treatment are done through a very closely connected network of regional providers. So it's worth it, if you will, to put in all that time and negotiation and relationship building to really craft a contract that makes sense, since they are going to be taking many children and many, many dollars, right? And so it makes sense to go through that elaborate process. In these urgent cases where we need to get a youth into a specialized program that is not part of that current offering, that's the situation in which, again, still require that high burden of, or that high bar from the certification, but we might need to do a one-off and not wait for the bureaucratic, slowness of the contracting process to play out.
Okay, follow up?
Follow up, sure.
So in other words, maybe both entities would be appropriate, that we contract some, but we just certify some?
Absolutely. And most of this bill helps inform and strengthen the process so that we're able, with the blessing and the passage of this bill to even strengthen our contracted oversight stronger. And again, that's why I sort of struggle with the sense of division here, because so much we're in agreement with. We're working together to take what is already a strong program. Again, a few years ago, there was no contracting process. Rates were not as nearly as strong as they are under our current budget. So much has gone on, not only to strengthen residential treatment, but to dramatically reduce the number of youth served. This is the lowest number. We've never had 4 kids being served out of our region. The success of our children's system of care work it's considered a model nationally. So what we're talking about is strengthening that contracted model while at the same time offering that occasional bit of flexibility when we need it for kids for which there's not a program within our contracted menu to serve them.
Thank you for allowing me to ask this question. On the contract, if the contract, it's a 120-day process?
At best.
Okay. And if they go through all the steps of developing this contract, let's say it doesn't get approved, does it leave the facility wide open for not being paid and opening us up to any legal ramifications?
I think that would be arguable, but the certification rules are certification for payment. And if they comply with the certification for payment rules, the administrative rules have the force and effect of law, and we would be bound to pay them under the certification rules.
Any further questions? Seeing none, with respect to the reallocation of money saved, are you okay with the money follows a child? Is there an identifier of the money following the child?
I think that would be extremely complicated. They don't have a certain dollar amount allocated that would be unspent. We pay bills as they come in. We try to be as responsible as possible, but there would not be, for example, a budget that's approved for the youth and money set aside from the youth that then would be moved somewhere else. It's more on a system level of whether or not we're spending that amount on residential treatment or not.
Okay, because I I just think it's important to find locations in the community that the money's already there and we don't have to go through the process of getting more money. So any further questions? Seeing none, thank you. Thank you. Now, I don't know if there's any questions for Mr. Fletcher, or we have a few DHHS representatives here. Are there any questions specific to Mr. Moore, Kaja Fox, Jeff Fletcher, Susan Larrabee? Representative, Mr. Fletcher, could you come up? Fletcher? Just identify yourself for the record.
Sure. Thank you. Jeff Fleischer, DCYF Director.
Great. Representative DeSimone.
Thank you, Mr. Chairman. Just a couple of quick questions, if you don't mind, sir. Thank you for taking my question. Thank you for coming here. I know how busy you are. You and I have spoken in various committees in the past, and you spoke about the fact that one of your goals is to keep all kids in state. Is that correct?
That would be a goal.
Follow up, sure.
Where are we?
We have about 81 kids still out of state, about 250 in state. And the region, as was stated before, we went from 15 kids out of region or more down to 4.
One more question.
Sure. One more.
I'm not sure if you're the one to ask this question to, and if you can't answer, that's okay. In order to make sure that these facilities are safe for these kids, optimally, how many inspectors do you think we need?
Yeah, that.
We only have 3.
Yeah, and that would be with BCBH, not with
Okay.
DCYF.
Okay.
But we are responsible for visiting monthly. So we do have probation officers and CPSWs going down visiting kids face to face on a monthly basis in all of our out of state facilities.
Thank you very much.
Thank you.
Further questions, Representative LeBay?
Thank you, Mr. Chair, and thank you for taking my question. Are the people that do visit these children have met the children beforehand and know what's going on with the case? Because as we know, children that see a familiar face or know a familiar name coming to them, they tend to be a little bit more welcoming to talk to that person, because a lot of kids, it's hard, especially in those situations, it's hard for them to trust someone to
Sure.
talk to, especially about situations like down in the facility there,
Yeah.
to open up about those situations.
Yes, good question. That would be our preference. But through scheduling, to send someone down to Florida or Texas or Arkansas at a moment's notice, it's difficult. There's people on leave, etc. So it's not always possible. On the other hand, to have people going down objectively who may not know the kid, but go in with a different set of eyes and meet the child and see the facility has some benefit to it. But our preference would be to have the actual worker go down to see their kids.
Further questions? I have one. With respect to financing, like the emergency we had in Bledsoe, you needed appropriations to look for other alternatives for these children. Is that identified? So if the children are pulled from out of state, that's at a 6, 7, 8,000. How much does it cost to put somebody out of the region?
Yeah, the rates vary with different
From
facilities.
5 to 10,000
5 to 10
a month?
a month, maybe if you're lucky.
Okay.
Yeah,
Yeah.
yeah, they're very expensive. The out-of-state facilities are usually more expensive than in-state.
Okay. So would you identify that funding for alternatives?
Well, yeah, we currently have existing. We have 260 kids in state now. We have facilities that have some openings, so they would move into that. So
Okay.
in this case with Bledsoe, they moved into another existing quality facility. And we're also building alternatives as we speak community-based.
with
so
current
kids-
appropriation.
Right, so they don't have to
Okay.
go to a facility. They can
Yeah.
stay foster home kin or with birth families with a lot of support.
Great, super. Any further questions? Seeing none, thank you.
Thank you.
I have two more cards here, and next I'll call up Nami Holly Stevens. Morning.
Good morning, Chairman Long, members of the committee. My name is Holly Stevens, and I'm the Director of Public Policy at NAMI New Hampshire, the National Alliance on Mental Illness. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide through support, education, and advocacy. On behalf of NAMI New Hampshire, I'm here today to speak in favor of House Bill 1573, which you've heard a lot about, so I'm only going to be brief in my testimony this morning. In September of 2022, there were 1,169 New Hampshire youth that were placed with other family members in foster homes or in group or residential facilities, which is a staggering number. You heard that there's about 440 in residential placement. There's another approximately, at least in 2022, 800 that were placed in other placements outside of the home. Research has found that compared with siblings who remained at the home, children placed out of home have an increased risk of violence, antisocial behavior, low education, common psychiatric disorders, depression, premature mortality by either suicide or injury in adulthood. It's further found that a foster home is better than an institution, and that having, as you've heard, only one and only stable placement is important for a child's stability and well-being into adulthood. We know that children have much better developmental and mental health outcomes when treatment is provided as close to their family and community of origin as possible, where the family connections can be preserved. We are in support of House Bill 1573 as it revises the criteria for out-of-home placements for children and increases the oversight and certification criteria for out-of-state residential treatment programs. However, we do have a couple of concerns with the bill. The first being the requirement that no children be placed outside of New England. As you've heard, we've got now 4 children that are outside of New England, and we do believe that due to staffing placement shortages, as well as certain specialized care that a child may need, that there should be an exception in the bill for children when there is no placement that can be found quickly for a child who may be in an emergency room, and or if you have a child who needs specialized care and that specialized care cannot be provided within New England, that there should be exceptions made for those children. Additionally, you've heard a lot about certification versus contracting. NAMI New Hampshire is an organization who has contracted with the state, and we can let the committee know that from our own experience that contracting with DHHS and the state can be very cumbersome and time consuming, and as a result could lead to the delay in care for youth. So we do have concerns about the contracting provisions because we have seen that it usually takes a lot more than 120 days to get a contract in place, and therefore there could be delays in the care of children in our state for the one-offs that you've heard who need to go to specialized out-of-state placements. NAMI New Hampshire is in support of House Bill 1573 while urging amendments allowing for exceptions to the restriction that no child be placed outside of New England and eliminating the contracting process that has been discussed. And with that, I will take any questions that the committee may have.
Thank you. Any questions? Seeing none, thank you. Oh, I'm sorry. Did you have a question? Representative Katab? Okay, we're good. Thank you.
Thank you.
The last card, Mr. Gilbert.
Good morning, Representative Long. Thank you for having me today. I just want to go ahead and recap some of the testimony that you heard today from both the department and OCA. The department went ahead and hit it right on the head with their lip service that we're expecting the department to govern themselves, something that they're already failing at doing. So with this, I do support the bill. I do believe that there is a need for this additional oversight. I do not believe that the department should be overseeing themselves. They do have that bureaucracy gap there that is causing a extreme amount of time and delay with regards to these children. I would perpetually say that OCA's rendition of what they're requesting is 100% valid, and the lip service from the department is just that, lip service. We'll go ahead and just give you a real sense of a real life situation that's occurring with my child and my family. My child is residential. That is what the bill is for, is it not? So out of region.
Out of home.
That is correct.
Yeah,
That is correct.
Child is placed out of.
My child is placed in a New Hampshire contracted facility
Okay.
at this current juncture.
Go ahead.
I will just say that my child left the facility yet again last night. This is a repeating occurrence that our facilities are not having the oversight from both the department and from DCYF, from behavioral health and DCYF. We've been requesting for over a year for my child to be removed from the residential facility that they are in currently. The child has been having sex on the unit in this residential facility with a lack of oversight and accommodations to ensure that these children are being properly supervised. My child has left multiple times with the facility not even recognizing or knowing that they're gone for multiple hours. This is a lower secure facility, so understandably, but the facility themselves recognizes that they have a severe crisis with staffing, and the department is not addressing that to ensure that we're addressing and not sending additional more children in there to be harmed. The staffing level of this particular facility, from my knowledge or belief, is around 30 to 40. And we're continually going ahead and, keeping that facility at that maximum capacity, really, when they cannot support that number of children. All the parties behind me are well aware of this. The department spoke lip service regarding my particular child in their testimony. So I really feel that there is some things that need to be done here, and we're going to keep driving this home for everybody.
Very good. Thank you. Any questions for Mr. Gilbert? Representative Panic?
Thank you for allowing me to take this question, ask this question, Representative Long, Chairman Long. And thank you for taking my question. You said that no one oversees DHHS. Doesn't the department have oversight through the DHHS Oversight Committee?
So I have attempted to reach out to them, and I was strictly and strongly protested by the former director and Attorney Baker when I attempted to go forward, saying that they were not going to allow me to speak before the committee.
Okay. Thank you. Thank you, Mr. Gilbert. Just one other question for whomever may be able to answer it. Is there an estimated time of stay in these out-of-home residential? Is there an average? Is there an average, or it's not? Or you can't stick to an average? Is it a year? Is it 6 months? Is it?
So don't have that information at my fingertips. I will say that the stays vary. Our commitment is to make these episodic therapeutic episodes of care. So they need to be always under the clinical, appropriate clinical supervision while regularly being reassessed through our comprehensive assessment process to ensure that the youth are better served in another setting. So I don't have I don't even know that we track that. But what we can say is that our commitment toward reform that we continue to work with advocates, with the child advocate on, et cetera, is for these to be, again, to avoid residential treatment whenever necessary, when it is utilized, to ensure that that is a episode. I can speak to level 5 because we just opened our first PRTF at Hampstead Hospital, and the stays there are roughly 6 months, a little in order to build skills for return to the community.
Okay, great. Ms. Sanchez?
Thank you for allowing me to answer this question. So this is actually the next step of looking at our residential care and the use of residential in the state of New Hampshire for the Office of the Child Advocate. So we're starting to try to dig into that data. We know there are kids that are languishing in care for multiple years. And so that is absolutely a concern of ours. And that is why it's one of the focuses of this bill is for it to be short-term episodic stay of treatment, because that is not happening right now. We have many kids that are lingering in residential facilities that are ready to move on.
Very good.
Thank you.
Having no more cards, I'll close the hearing on 1573. And I'll ask if, would we be ready to exec this? Anybody gonna, yeah, I'm clear on contract to certification. Anybody? Are we ready to?
I'm just wondering, are we supposed to be looking at the 2 amendments and the bill and then execing on whichever one is best? And
Well,
personally,
yeah.
I think we'd need a little more time, or I think I do.
Okay. You agree you need a little more time too?
Yes, just so that we can go over the amendments kind of more thoughtfully. This is a lot of information to take in.
Yeah, we just had an hour and a half on it, so. All right, so I guess we'll wait, I guess, huh? All right, very good. Thank you.
Mr. Chair?
Sure.
Can we move exec possibly toward the end of the day to give people the opportunity to peruse the amendments submitted and re-ask?
Yeah.
Do we want to,
Yeah, well, the thing is,
what's the consensus?
This is going to a second committee, which has to be out, so we'll have to come back.
Well, why don't we just take a simple vote on it if we want to exec it or not? Because I guess multiple people are
Okay.
having different opinions.
Okay, those that feel they have enough information to exec now, can you put your hand up? So 3, 4, 5, 6, 7, 8, 9, 10, 11. So those that don't, put your hand up so I can make sure I'm counting right. Those that don't fit, you're gonna go? Great, we're gonna exec, Mr. Chairman. So with that said, I'll open the executive session to House Bill 1573 FN.
Mr. Chairman, for a motion?
Chair recognizes Representative Pearson for a motion.
Mr. Chairman, I move Amendment 2024-0427. That is the amendment brought forth by DHHS. I move this as ought to pass.
Okay, Representative Pearson moves amendment 2024-0427H, seconded by Representative D. Simone.
May I speak to my motion?
And you may.
Thank you. As everyone said, as doing side-by-sides, I agree. The 2 amendments are very similar. In fact, when the Office of Child Advocate's deputy spoke at some length about what the court needed to do, I first got the impression that that was something that only their amendment spoke of, but in fact, looking at the DHH amendment, it's in there pretty much word for word. To repeat, These bills are virtually the same. The only difference has to do with certification versus contract. Testimony was given that this is only 1% where there are not contracts, that all the others are in contracts. And testimony was given that 120 days to hop through all of these hoops is a great thing if it happens, and that flexibility is needed. So I believe that the DHHS amendment gives us 99% of what everybody wants, but on the one issue of contracting, it is my opinion, DHHS amendment is the better one.
Very good. The only thing that's not in this amendment that I'm interested in, but it appears that we may not be able to track it, is the money following a child. I think it's important because if we're saving money, the state has a tendency to save money. And my goal would be to have that money go into the child in some other alternative, and I'd like that identified. But my understanding is it's really not identified. Evidently, there's a fund they use for these alternative programs. When it runs out, they may have to go to cover council to get more. Am I in line saying okay? So that's correct. All right. Yeah, that would be the only issue that I would like to add. I want to be assured that the state's not gaining revenue by saving money when we need it to go to this child. Representative Pearson?
Is it your experience, as it has been in mine, that sometimes at these hearings, when we kind of like something, the department hears that?
Yep, absolutely. I see them shaking their head, and it's
You
giving me
might-
that warm and fuzzy
Sorry,
feeling.
that's inappropriate.
Yep, no, that'd be good. Okay, yeah, so I'm clear I'm clear on the certification and the contract, and it appears to me the contract is a little more complicated and a little more holds back the child. And I wasn't clear as to the advantage of, I am clear on the accountability aspect. That accountability needs to be there, whether it's less than 1% or whether it's one child. That accountability needs to be there.
Right.
And we need to follow up with that. Any further discussion? Representative Perez?
Yeah, I just wanted to say that my concern is I want to make sure that these kids don't have to wait so long in order for something to happen. And that's the only concern that I have, because from what I hear from both testimonies, it seems to one is very concerned about the timing, how much time that the kids has to wait in order to get out of that situation. And that's the only concern that I do have. Time. We should not be putting these kids to go through weeks and weeks and weeks of waiting. If it's something like this happen again, I just want to make sure that these kids don't have to wait so long and suffer alone. We're responsible for these kids, and we should make things happen quickly. Thank you.
That's a good point. Further discussion, Representative Craig?
Yeah, after here, I understand the difference between the contracts and the certification. I just want to make sure that we're not saying, and I understand the time. I mean, certainly 672 hours for those kids to wait after we figured out they were in an abusive situation is 672 hours too long. So I want to make sure, though, that we're not cutting corners to make, that we're saying, okay, this will be quicker, so let's cut this corner so that we can make this quicker. We have to have both. I would feel better if I felt like DHHS was like, yes, this was a stop and we should have done this, and maybe that's a legal reason that they're not saying anything. But I think there is more accountability in this amendment, and I think that's fine, but it's certainly something that I would be continuing to watch very closely to make sure that this is enough.
Any further discussion? Representative Gibbons?
Thank you, Mr. Chairman. I'm just wondering if the finance department would be able to, is this going to finance committee after this? So they might be able to address your issue about appropriating the funds if they're not used? Maybe we could just send them an email? Okay, thank you.
Any further discussion? Okay, seeing none, I'll ask the clerk to call a roll on amendment 2024-0427H.
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Katab,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino is not here. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond,
Yes.
15 yeas, 0 nays, and
Okay, so the amendment,
1 absent.
the amendment passes 15-0. I'll recognize Representative Pearson for a motion.
Thank you, Mr. Chairman. I move on House Bill 1573 as amended by 0427 ought to pass.
To pass as amended.
Second.
Second by Representative Perez. I want to thank Representative Pearson and all the co-sponsors on working on this. This is very progressive. It needs to happen. I appreciate it.
And Mr. Chairman, the neat thing about it is if we find that there's a little place that isn't quite working as hoped, we're all back next year.
Yeah, you got it.
Well, some of us are back next year.
So,
Your lips to
On the-
God's ears.
on a motion of ought to pass as amended, House Bill 1573, if the clerk, when she's ready to call the roll.
Chairman Pearson,
Yes.
Vice Chairman Long,
Yes.
Representative DeSimone,
Yes.
Representative Bickford,
Yes.
Representative Katab,
Yes.
Representative McMahon,
Yes.
Representative Ball, yes. Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Levesque,
Yes.
Representative Petrino is not here. Representative Perez,
Yes.
Representative Gregg,
Yes.
Representative Moulton,
Yes.
Representative Raymond.
Yes.
It's 15 yeas, 0 nays.
Okay, great. Thank you, everybody, and we'll see you all Thursday.
You may all
No,
come
wait,
back
wait,
in
here
10
more.
minutes, please. This is
All
a
right, we got a
stretch
10-minute
break.
break.
We
Great.
have a
Thank you.
lot of work to do, and the clerk will know I have my blurb ready.
Thank you for what you did. I want to cry. That was awesome. I know. You did it. You did it.
So much fun.
Yeah, I know. That's really sad. And it involves human beings. Kids.
Oh, it does. Oh, it does.
Right. No, you did a great job. Thank you.
Yeah. Because they emailed me saying that I was. Yeah. So I was like, no, no. Yes.
Down there.
in the wrist. I'm starting with a couple of items of bad news. Representative Levesque no longer has a Girl Scout troop, so we'll have to get our cookies elsewhere. No longer have a quorum. Opening an executive session on House Bill 1189, criteria for reporting child support delinquencies to the feds. And you remember that was Representative Spillane's bill. And the chair recognizes Representative Seidel. Backlit as always. Thank you.
Thank you, Mr. Chairman. I'd like to introduce the amendment to House Bill 1189, which is 0186H.
And do we have it? We do.
It was handed out this morning.
Okay, in the pile of stuff. I'm gonna read his. And would you you are moving Amendment 0186H, moved by Representative Seidel. And do I have a Democrat who might like to agree? Or Socialist Workers' Party of America? Or somebody else? Anybody? Who was I? Simone, got it.
What did I do with my pen?
Thank you. All right, take a minute to read through it. And when you're ready, Representative Seidel, would you care to discuss what the amendment does in light of the hearing to improve the bill?
Thank you, Mr. Chairman. What this is for is to address the concerns that we had in committee.
Would the mic be closer to you, please?
I'm sorry.
Thank you.
You're welcome. Thank you. One, giving ample notice to the obligor of the department's intent to report. We had in testimony that they never received any previous warning and was reported to the passport denial program, having their passport denied without them being in the correct arrearage amount at the threshold of the federal government of that program. It also requires DHHS to submit the individual obligor's pay frequency into the department's software to avoid arrearage triggers of unnecessary reporting to the federal agencies.
Any questions or discussion? Representative Grossman.
Thank you, Mr. Chairman. So this would be introducing a new automated system. Is that a new system to My question, is this a new system being added or?
According to the woman that was here, I think her first name was Lily, with DHHS, she said their system was capable of doing that, of breaking it down, and she believed that it was at some individual cases.
And is there a cost associated with the update?
Not that they presented. She said this bill will have no impact on DHHS.
Okay.
Anything else from anyone? Give you a minute.
Mr. Chair, do you, or does anyone know if this was run by the department, Child Support Department? Oh, it was? The amendment?
Representative Seidel or anybody?
Well, can we ask?
You can ask.
Oh, the folks there?
Anybody know?
If I may.
You may.
So, Mr. Chairman and committee, just looking at my notes here, we had a lady from Child Support Services, Lisa Dekotowski, and she made a statement that said they already maintain an automated system that would be able to respond to what is being requested here. So, so that the comment was a positive one.
Yeah, well, the 10 days is, if that's enough time, for one thing. But she's right here with us, so I didn't know, but it would be okay to inquire. If we've got a good amendment here that works for them, works with them. It's up to Mr. Chair.
I'm asking Representative Williams, yeah, I keep insulting you, I'm sorry. Counselor, lawyer, Esquire. Yeah, yes, you're not paid by the word, yes.
Right here, John.
You see how quickly we degenerate into chaos now that I'm back in the chair? Thank you. This was supposed to be a slam dunk. Please. What was the question?
Right, what's the question?
She's about to answer it, and it will be better if she knows the question.
Thank you, Mr. Chairman. How does this work out for your department? And like the 10 days, that sort of thing. Are there any problems with it? Is it going to be a smooth transition, or does it, does it work for you?
I would have a concern with the 10 days only in that I'm not sure it gives the obligor time to respond, in that if we send something out and in 10 days we're going to report them, that by the time we do something through the mail, to get them to be able to respond. And that would be a burden on them. So I think a longer time would be good. The other issue we have is in paragraph B, that's all new. And there's definitely going to be some changes to our system that are going to be needed. We did not previously do a fiscal note for this bill.
Representative Long.
Thank you, Mr. Chairman. The bill takes effect in 60 days. So that's problematic, I'm assuming.
That is also definitely
All
problematic.
right, thank you.
Representative Grossman.
Thank you, Mr. Chairman. So, seeing this amendment now, do you think there would need to be a fiscal note attached to this upgrade?
Definitely.
Okay, thank you.
Should we chip?
Yes, one more follow-up.
Is this an issue that comes up often? So for our committee, we've only seen this issue come up before with one case. I'm just curious if this is an issue that you see happen more than once.
the different touch points where these issues are brought up. We give a lot of information to the obligors who come to our program. When they first get signed up, they get a lot of information about wage assignment and about all the different kinds of collection. Then they get a notice of debt once they get to a certain amount, and that talks about all the different kinds of enforcement that can go against them. And then there's what's called a PONS notice, which I'm sure stands for something. And that deals with specifically with tax offset. So notice is generally a big thing in child support, and notice ahead of time is definitely better.
Representative Panic.
I'd like to
an upgrade on your next door neighbor here, I must say.
I'd like to respond to Representative Grossman. If I recall from Spillane's original testimony, I think he said there was something like 400 cases that had that problem, if my recollection from my notes.
Anyone else? Before I call the question, I just going to ask the committee if you really think that with the amendment, it's good to go and they'll get it done as they get it done. And, it takes effect in 60 days after the House approves it, the Senate approves it, and the governor signs it. Because if we are going to delay and ask for another amendment, I'm not sure we can get it in under the wire. So are we good to go? Representative Long?
Thank you, Mr. Chairman. So if I remember testimony, there was not a notice given to Representative Spillane. That was one issue. I don't believe that was 400 people. My understanding is that it's what was it, $2,500 or $5,000 with respect to passports?
2,500.
2,500. His was $5, I believe. So I mean, is that possible that I would be in arrearage for $10 and my passport would be withheld from the feds because they don't know? Because your report just says I'm in arrearage. It doesn't say $10 or $1,000 or $2,500.
No, because our system only reports them if they're over the amount.
All right, so the automated system reports when they're over the $2,500 to the feds. Okay, and how?
And just, we cannot discuss the details of Mr. Spillane's case.
He did.
Right, he did, but.
They can.
Okay. Okay, I'm fine. Thanks.
Representative Ball?
Thank you, Chairman Pearson. If I recall the testimony, it was that you report when it's over 2,500, but you do not take it off the list until it's zero. So in other words, it can remain on there even if it's only $5. Is that correct?
That's correct.
Thank you.
Sure. Yeah.
So originally it was over $2,500?
Correct.
Okay.
And so if once it's hits over $2,500, it gets reported.
Okay.
And then it doesn't fluctuate back and forth if you go back and forth over and under and over and under. It's there until it goes to zero.
Okay, thank you.
Representative Raymond?
Thank you, Mr. Chairman. So as I'm reading both the bill and the amendment, I don't see anything in this language that would change someone who hasn't completely gotten down to zero from having to still work with the passport office to fix that. Nothing in this changes that, right?
Correct.
Okay.
I thought I saw another hand. I did. Representative Ball?
Thank you, Chairman Pearson. I think that what it does say, if I'm reading this, that you would not continue to report it if it doesn't meet the federal threshold. So in other words, once it's under the $2,500, it should be removed, or maybe I'm reading it very quickly. I'm sorry, I'm trying to do two things at once. Am I reading that correctly?
I suppose it could be read that way. That is not the way we read it, as the reporting of this to the federal government that's the way that the federal government does it. That's not something that we've made up that says we're just going to keep reporting it even if it goes below. That's how the system works.
Follow up.
If I recall in testimony, isn't this a situation where if you're getting paid bi-weekly half the year, you're always going to be in arrearage? Was that this one, or am I mixed up? Because it's divided into 52 payments, so at every other week you're going to be behind. I'm sorry, I'm just trying to recall what that.
Sometimes it can be possible, but somebody would have to have a very large order to be $2,500 behind every other week.
Will they follow up?
Follow up.
Isn't it possible that some people have very large orders?
It is, and in cases like that where we see that would be happening, we can exempt a case from being reported automatically, so that we don't hit that.
Thank you.
Representative Gregg.
Thank you, Mr. Chairman, and thank you for taking our questions today. So just to recap, I just want to make sure, because this is a bill that we've kind of been back and forth on a couple of times. If someone has, like, say they have this thing where it's biweekly, but they get paid, or it's weekly, but they get paid biweekly, there's a way that they can, from what you said before, that can be adjusted. Like, it's not just, you guys aren't set in stone, like you have to be biweekly. So there's a way for somebody to have personal responsibility to make sure that they're not falling into arrears by changing that schedule or by working on that schedule. Is that correct?
Our systems can take into account when somebody gets paid, their money's coming in weekly, and then depending on how the child support is ordered, it can be a monthly amount, it could be a bi-weekly, that type of thing.
Okay.
So it'll accrue bi-weekly, money comes in monthly, and then of course somebody changes and that changes again. But
Yeah.
the order accrual stays the same with the court order until it changes.
Okay, but it's not like they're, sorry, follow up.
Follow up.
It's not that but there's not an inherent like setup to fail on this. Like there's a way that somebody can work with the system so that they're not always behind or whatever.
Correct.
Okay, thank you.
Seeing no further hands, the motion before us is on Amendment 0186, moved by Representative Seidel and seconded by Representative DeSimone. And when a clerk is ready, please call the roll. Welcome back.
Thank you. Chairman Pearson.
Yes.
Representative Long.
No.
Representative DeSimone.
Yes.
Representative Bickford.
Yes.
Representative Kutab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
No.
Representative Levesque.
No.
Representative Petrino will be voting no. Representative Perez.
No.
Representative Gregg.
No.
Representative Gibbons.
No.
Representative Raymond.
No.
8-8.
Would you tell me again how you voted? I didn't hear you. I'm sorry. Did you vote yes or no?
I voted no.
No. Okay, so it is 8-8 then.
8-8.
Which means it fails. So we are back to the bill itself. And would somebody care to make a motion on that bill itself without the amendment?
Yeah. I'll move ITL.
Representative Long moves ITL, and the second by Greg Long and. I'm sorry? Greg is over there. I know. I thought somebody's going to make me a seating chart. All right, Grossman. Any further discussion?
Yes. Right here.
Representative
As usual.
Bickford.
Please, someone give me some indication as to why I should either vote yes or no on this, because I
Because
just
those are
don't
your only
remember that.
choices.
Huh?
Those are your only choices.
No, I still didn't hear that.
Well, if it helps you, I'm voting no on ITL.
Well, I was looking for an explanation of the no.
This is an issue that needs to be dealt with. You have people who are being denied passports for something that's beyond their control due to the current reporting situation. It's not. Oh, I'm sorry. Oh my gosh, my pet peeve.
Were you talking?
No. I never said a word.
That means you can repeat it.
What I'm looking for is,
Probably not.
we got an amendment on it, so that means somebody thought they could do it better with an amendment or something defective in it. So what is it that's right about it, or should we just move it to get it to the Senate so these folks over there can fix it?
Well, Mr. Chairman.
Go ahead.
Go ahead.
May I?
Representative Perez, I thought she was going to say.
Oh,
something.
thank you.
Yeah.
The reason that I'm supporting the ITL motion on this bill is because, to be honest, I keep hearing that this happening to people, and it is a lot of people. Where's the people when we need them to come in and testify? Where's the online testimonies? To be honest, if this is a real issue, not just a couple of people issue, I wish I can see people coming in and really tell us, the real story behind this bill. That's all.
Representative Gibbons.
Thank you, Mr. Chairman. The feedback that we got from New Hampshire Legal Aid said that they opposed the bill relative to the criteria for reporting child support delinquencies to federal agencies, because if passed, it would put the state system out of compliance with federal requirements. So we don't want to cause like a mismatch between state and federal.
Representative Gregg.
Thank you, Mr. Chairman. So to build on what Representative Perez says, this seems to be legislating for one particular case. That's the only, and it's the bill author. And I struggle ethically to pass a bill for one person, especially when we heard testimony from that person multiple times about multiple different areas about how in arrears he was. First it was pennies, then it was a couple dollars, and it was $5, and we never saw paperwork to say that this is what it was. We heard contradictory testimony from the Office of Child Support saying, no, this is how our system works. We can tell somebody how much they're in arrears. It doesn't, we've looked at the federal guidelines, it doesn't trigger until $2,500. I mean, at the basis, we're here for the kids and to make sure that they're getting their payments. And this, because one person is having an issue, I don't see why we're legislating a bill for one person.
Anyone else? Yes, Representative Ball.
Thank you, Chairman Pearson. I don't think we're legislating for one person, and I do think we're legislating for their children if that one person could not get their passport in order to go see their children. That could be a case out there. I think this is a case where there's smoke, there's fire. If one person came up who happened to be a legislator that this happened to, so he knew there was a way of dealing with it. The average person is just going to say, you can't fight City Hall. This is the way this is the way things are. I think that we were fortunate that it happened to a representative who could bring it to our attention, because I'm sure that's happening to more than just him.
Oh, you can't now.
Anyone else?
Panic.
What?
Sandra Panic.
Representative, see, I have a nice seating chart now. Now all I have to do, thank you. Now all I have to do is see. Okay, Representative Panic, thank you.
Thank you, Representative Chairman Pearson, for allowing me to put my 2 cents in. If I recall, when Representative Spillane did his testimony, he was consistent about it being $5 in the rear. Because every time I sat down, I write notes on my paper and I date on the back of it what was said. So I see the consistency here. He was going to go for a job in Canada. He was doing a job in Canada. He could not do that job because he was not able to fly to his job. So that hurts his family, you know, I think a simple software fix, and he did say numerous times there was over 400 people that he personally knows of that were, you know, affected by this type of situation. And it's a simple fix, a computer fix, a software fix. That's it.
Representative Long.
Thank you, Mr. Chairman. I'm voting yes on the ITL, especially where the amendment didn't pass. The amendment would have detailed better this fix. Again, when I look at it across the board, I'm not getting constituents that have a complaint, and I've spoke to plenty of them that have been in arrearage, 500, 1,000. The claim was that they never got a notice, but they were alerted by Passport that their passport had to be redone because they were in arrearage. Now we heard today that in order to get that notice to the feds, they got to be $2,500 in arrearage. So, I don't see where that's I don't see where that was stating. So I'm not sure of where the glitch is, but there may be a glitch somewhere. And also, there's no fiscal note. It has testified to today. There's going to be a cost to this. What that cost is, I don't know. So that's why I'm going to vote to ITL.
Could I ask the agency if ever an investigation was launched as to what went wrong in the case of this individual, because he got the notice and yet he shouldn't have gotten the notice, but he got one. So why? Was there ever any attempt to find out where the hiccup was that you may legally answer us?
Unfortunately, I can't address anything that specifically happens in any particular case without a waiver of confidentiality under our confidentiality statute.
Understood. Representative Katab.
Thank you, Mr. Chairman, and thank you for taking my question. Could you tell us, I assume after seeing this bill, that you would have researched and looked into to see if you could find and identify any potential cases where the person was in arrears less than $2,500, where something like this may have happened? Did you find any such cases? I'm not asking you specifically names or who they were, but did you find any such cases that existed?
I did not do any research to that end, in that's not my role. I wouldn't know. I would have to have asked somebody to do it, and I don't believe that we looked into it.
Representative Raymond.
Thank you, Mr. Chairman. So I'm uncomfortable with the back and forth. So my question is regarding changes that this bill would create within the child support department. Because my notes from last time is that there is no fiscal note because this bill would not change the practice of the department at all, were it to pass, which is why my vote will be probably ITL unless I'm told differently right now. Because my note says that you take the position you're already in compliance. It's a federally certified automated system programmed with the federal guidelines for reporting, and you do include the amount that's sent to the feds. Therefore, this isn't going to cost any money because there's literally nothing that you would do differently.
Yes, that was our analysis when on the original.
Okay.
The original.
Has that changed as of today on the original bill that we're discussing?
No.
Okay. I'm sorry. Thank you. That was rude of me to just sit back.
Anyone else? The motion before us is ITL, moved by Representative Long and seconded by Representative Grossman. And it is unamended. The motion is ITL. If you are for ITL, you vote yes. If you're against ITL, you'll vote no. Mr. Clerk.
Chairman Pearson.
No.
Representative Long.
Yes.
Representative Disimone.
No.
Representative Bickford. Representative Katab.
No.
Representative McMahon.
Yes.
Representative Ball.
No.
Representative Panic.
No.
Representative Seidel.
No.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Petrino will be voting yes. Representative Perez.
Yes.
Representative Gregg.
Yes.
Representative Gibbons.
Yes.
Representative Raymond.
Yes.
10-6.
The vote is 10-6 in favor of the motion of ITL. And would Representative Long please write the committee report? And the committee chair representing the committee does not organize the negative report. So of the 6 people who voted no, one of you, please, which one of you would wish to write the minority report?
Mr. Chair, I see 7 that voted no. Who voted yes, beside Representative Bickford?
McMahon.
McMahon voted yes.
It's
Thank
10-6.
you very much.
Yep. So I will give about 30 seconds for those who voted in the negative to look at each other and decide. You will do the minority report.
Got it.
Okay, and you will do the majority report, the committee report, and we're going to have lunch pretty soon, so. Okay, Long. All right, this concludes the hearing on House Bill 1189. I now, the executive session on 1189. This now opens the executive session on Bill 1111. And the chair is looking over to Representative Seidel for a motion.
Thank you, Mr. Chairman. I'd like to introduce an amendment to House Bill 1111-FN. It is number 0245H.
And would you please, and is there a second on that? Second on that amendment? Okay, I saw you first, Representative Gibbons, I've just changed my seating chart to Gibbons. Update. Representative Seidel, would you please speak to the amendment?
Yes, thank you, Mr. Chairman. This amendment was drafted to address the concerns of this committee. One, on lines 24 and 25, it removes any civil or criminal immunity from a mandatory reporter who fails to make a report of suspected child abuse and neglect. And it also adds 2 new sections further outlining the failure to report as well as reporting with malice or intent to harm.
Any questions regarding the amendment? You need a copy of 245H somewhere.
It's got a staple in it.
Yep.
Representative Bickford.
It was with the one we just did this morning was right, they were together.
Anybody have a stray 0245? Hey, I do. How about?
Mr. Chair?
Yes.
Sorry about that. Didn't we do something similar to this term? We did? Somebody said yes. Oh, you. And you remember what number it is? Okay. And what happened to that? I mean, are we duplicating? Oh, it's been in the Senate already?
It failed in the Senate. It was last year, yeah.
Okay.
But this is sufficiently different, apparently, that it is allowed to come in this year.
Yeah. Right, right.
What I like is if you're going to have a law, has some teeth. If you say thou shalt not, there's got to be an or else. But I think the amendment is good in that it is restrained. You'll notice on lines 24 and the following, nothing shall provide civil or criminal immunity for a mandatory reporter who knowingly fails to make a report. As a mandatory reporter, I take that very seriously. And I will err on the side of caution, knowing that it has to be investigated. But I cannot publicly speak to those who may have knowingly failed to do it for any number of reasons. And I like the teeth in this. If you see it and you should say it, you must say it. So it's teeth, but it's teeth within reason, I think. Representative Long?
Thank you, Mr. Chairman. So we're all mandatory reporters. So if I don't know if it's abuse and neglect, I'm not going to report it, because if I report it, I may be charged for filing a false report.
No.
You'd be a good faith.
Well, that's what I'm reading here.
If it's good faith.
Not if it's in good faith.
If it's in good faith,
Oh, okay. So if I do file a false report, all I got to say is that I did it in good faith.
it's up to the department to figure that out.
Well, it's not up to the department, it's up to the court.
Well, whoever does the investigation.
Yeah, okay, and I just don't see where this helps with the issue that we have. It's still up to the court. I don't know how those are brought forward to the court. Maybe the other party that's being charged with abuse.
Let's start at the middle. Representative Gregg.
Thank you, Mr. Chairman. And thank you, Representative Long or Vice Chair Long, for bringing that example up. So when we're looking at a bill like this, you know, and what we're talking about reporting, and we know that the people that take in the reports have already said, please don't do this because they have a great system for vetting. Those that are conscientious are going to be the ones that are hesitant. Those that are worried about, you know, maybe saying that it's abuse and it's not abuse. Those are the ones that we're actually going to make hesitate more with legislation like this. Those that are doing this for malice or doing this to be cruel, they don't care about this kind of legislation. They're doing it anyway. False police reports, those are already against the law. We already have, you know, measures to help keep that. So all this kind of legislation does is it makes those that are conscientious, that are thinking about, oh my gosh, could I be doing this, hesitate. Not the ones that are doing this for malice. They don't care anyway. They already know that you can't do that.
So your conclusion about the amendment would be what?
I would not be in support of it.
Okay. Representative Raymond.
Thank you, Mr. Chairman. I'm the one who pointed out during our hearing about how a lot of other bills who have penalties for false reports, a lot of other states have penalties for false reports, like my former state of New York, have penalties for mandated reporters who fail to report. And so I appreciated seeing an amendment that had that. I can't support it because it says for a mandatory reporter, but New Hampshire has this weird mandatory reporting law that no other state in the country has that says that every adult in New Hampshire is a mandated reporter. If this had the qualifier that it has later on in the bill where it says a professional mandatory reporter, so on page 2 under item 9 it says any person in their professional capacity is a mandated reporter, I would feel better about it. Because really what the point of having a penalty for someone failing to report is to get those doctors and, you know, school professionals and other professionals who should know better who aren't reporting. But this hits, you know, your neighbor down the street. And that's not the intent. I don't want the neighbor down the street who has a genuine concern about these kids to not call it in because they're worried that they're going to get in trouble with the law for failing to call it in. I also don't want the neighbor down the street to not call it in because they think someone's going to think they're lying. Like, we want people to call and we want the experts at the state to do their job. So I can't support it. I appreciate the try though.
Representative Gibbons.
Thank you, Mr. Chairman. My stepmother is a social worker, and I've talked to her extensively about this subject, and she does confirm that there are plenty of false reports that are made to, she's in a different state, but regardless, if they exist in other states, they exist here too. There are plenty of people that make false reports, and she wishes that her state would enact some penalties because it would deter the false reports. You're right that there are some people that are malicious enough to know that they might face consequences and then do it anyway. But the whole point of creating a law against false reports is so that you can convict these people. You can't convict them if there is no law about it. So first of all, false reports do happen. Secondly, we need there to be some type of consequence for false reports. And, you know, maybe it's a difference of opinion that I have with some of my colleagues, but I don't think that this would deter regular reporting, because if you're reporting in good faith, you don't have to know. It's not your job to do the investigation. If you're reporting in good faith, then no harm comes to you. It's if you're reporting in bad faith and the department investigates it and they find that it was in bad faith, that's when you can get convicted. So that's it.
Representative DeSimone.
Thank you, Mr. Chairman. I used an analogy that happened to me. I heard a neighbor using horrifying language to their child. I felt it was abusive. I contacted the correct phone numbers and spoke to a person and said, I'm hearing this abuse going on continually. I don't know if it's illegal or not, but this child and family should be investigated, blah, blah, blah. I did get notified later that the language wasn't considered abuse. So a year later, I saw the person specifically hitting the child, called again. My point of telling that, and it was found abusive, they were investigated and they were helped, they were assisted in understanding what the difference between abuse and not abuse was, and the family thrived after that, and I was happy. My point of saying this is, one of the things that I called about was actually, I still believe it's abusive, but by law, it's not abusive, but it didn't deter me from calling again. And this was long before I was involved with the legislature. So I don't see this affecting people who legitimately call because they believe there's abuse, but I do see it affecting people who are a disgruntled acquaintance, however they're acquainted to the particular person, of calling and continually giving false reports. And that's why I think that this is an important amendment to pass. Thank you.
Long, please.
Thank you, Mr. Chairman. So currently, you could file with the court if somebody is maliciously saying that you're abusing or neglecting your child. So this does nothing to add to that enforcement. And what it does do is, as a required reporter, we're all required reporters. I believe that it'll make people think if this is standing forward. So this does not add more enforcement. This does not fix the problem. The problem is still going to happen. You're still going to have to go to court. It's not up to the department to determine whether they were malicious.
Representative Petrino.
Thank you, Mr. Chairman. So I think our number one concern here is protecting children at all costs. Now, I understand that some people may call in false reports. Some people may call whether they're fearful or not, and others may not call in because they're fearful. But the bottom line is, are we concerned with convicting individuals for false reports, or are we concerned with protecting children at all costs? And so the bottom line is, let's protect the children, regardless of who's making the phone call, whether the calls are sincere and well-intended, or whether or not they're false. Always best to err on the side of caution. Thank you.
Professionally, over the years, I've known several people who were the victims of malicious false reporting, and I sure want to protect them too. So hand this way, Representative Panic, then.
Thank you, Chairman. On line number 12 through 17, it says reports made to the department may include the name, address, and phone number of the person or persons making the report. So that would be a detriment, because right now you can send a report in, you can put a report in an anonymous report, and you have nowhere to go if it was a false report. If this person has to leave their name and address and telephone number, that's going to be a deterrent from them giving a false report.
But if it says may include, they don't have to.
Oh.
That's the operative word in that
So we
sentence.
need to change this to they shall.
Well, this is the amendment we've got in front of us. We can't change it right now. Representative Perez.
Yeah, to be honest, this bill concerns me. If someone who is a survivor and someone who tried to report many times, and I know people try to report domestic violence and child abuse. This is concerning me when it comes to victims. We're not protecting victims. We put them on the eyes of the abusers just to continue doing what they have done.
Representative Gibbons.
Thank you, Mr. Chairman. Another perspective is that when people make malicious reports, it can separate families if it's pursued as though the report, if it's pursued as though it's a real report, it can cause harm to the families. So one can look at the situation as we're protecting the children if we're discouraging false reporting. And to circle around to Representative Panic's statement, you can still, according to the way this amendment is written, you can still report anonymously, and we do want to protect that. You're encouraged to give your information so that they can circle back with you, but you still have the right to be anonymous.
Representative Bickford.
Thank you, Mr. Chairman. If I recall correctly, I believe attorney, counselor, et cetera, Esquire, Williams came in and spoke to us on this, didn't he? On this bill? Shake your head. Good. And told us that there was no issue over there at DCYF. That's what I understood.
This would not go to DCYF, but to law enforcement, the good counselor said, quote.
It's a law enforcement because it's being overused. That's the belief. Someone's overusing this by making apparently a lot of phone calls and apparently not anonymously. And so they're going to be charged. I feel it would have a chilling effect. I did before. I was a student of Dr. Mary Stewart Guile, who used to be the chairman of this committee. And she insisted that where everyone was a mandatory, when we made it that way, I was on the committee at the time, that we shouldn't do this sort of thing. And because I thought the same thing, I think we should do it. And where there's not a problem with DCYF, which handles this stuff, as being overburdened and everything, I don't think it's necessary. I don't really see, people shouldn't be a victim of false reporting. DCYF comes over and knocks on your door and says, can I talk to you? And if there's nothing there, it's not a problem. So they're not really a victim of anything if they're good actors. And DCYF is a good actor too, and of course we do believe that.
During the hearing, Representative McMahon asked Director Jeff Fleischer of DCYF, do we need this bill? Mr. Fleischer said, yes, we do.
I think that was during the hearing, or sometime John Williams came back and said that was an error.
Yeah, I got Mr. Fleischer and Mr. Williams said there's no need for this bill.
I must have been using a Republican pen.
Well, I write my notes during these discussions.
Okay, so that one ended in a tie. Anyone else? Representative Katap.
So, assuming that we're going to take lunch at some point, I noticed that Rep. Raymond mentioned that she liked the majority of the amendment, except she didn't like the fact that it wasn't saying that it didn't have, if you failed to report in as a professional reporter. Perhaps if we're taking lunch, we could ask OLS to make that change, if that would then make her supportive of the.
Mr. Chairman, if I may respond.
Yes.
That is an issue that I have with the amendment. And I appreciated the attempt to address my question at the hearing. However, I still feel very strongly that there are ways of handling people who are using DCYF as a weapon that don't require this type of legislative solution. And in my experience, and like I said, I worked in a state as a worker where there was a law like this, and I've worked here where there isn't. And in both cases, the majority of the false reports or using DCYF to harass someone is in a high conflict domestic violence situation. And this bill, I don't believe, will have any impact on that whatsoever, because in those high conflict domestic violence situations, it's about power and control. And that person is going to utilize whatever tools they have at their disposal. And I have never seen in my professional experience anyone prosecuted for calling too much, because it's impossible to say that a parent doesn't have a genuine concern about the safety of their child, even when you know that that parent has a history of domestic violence and inappropriate behavior to the other parent. The only case I've ever seen prosecuted was a fail to report by a school guidance counselor. I've never seen anybody prosecuted in New York either for calling repeatedly on their neighbor or calling repeatedly on their ex. As a worker, you'd go out and say, listen, if you keep this up, we are going to send the police out to talk to you. But that's like the most I've ever seen have happen. So,
Representative Gibbons.
Thank you, Mr. Chairman. The other side of that, though, is that you were working in another state that had this law on the books, and there's the potential that it deterred that type of behavior, meaning you didn't see it prosecuted because the law was effective.
We have before us the amendment 0245. It is a replace the entire bill kind of amendment. If this amendment fails, then we go back to the original bill. The amendment 0245 was moved by Representative Seidel and seconded by Representative Gibbons. The clerk, please call the roll on the acceptance of the amendment.
Chairman Pearson.
Yes.
Representative Long.
No.
Representative DeSimone. Representative Bickford.
Ought to pass, right? So,
Can pass.
I'm a no on that. Yeah, thank you.
No on the amendment. Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
No.
Representative Levesque.
No.
Representative Petrino will be voting no. Representative Perez. Oh, she stepped out. Okay. Representative Gregg.
No.
Representative Gibbons.
Yes.
Representative Raymond.
8-7, it passes.
No, I have 8.
7.
1, 2, 3, 4, 5, 6, 7.
The amendment passes by a vote of 8
8
to
to
7.
7.
And now we have before us House Bill 1111 as amended by 0245, and the chair is looking at Representative Seidel for motion.
Thank you, Mr. Chairman. Kind of in my own little world.
Got something else going on there,
I
baby?
will move to, I'm sorry?
No, never mind.
No.
Yeah, it's just
A motion to OTP.
OTP.
HB 1111
And that is by
FNA.
Seidel. And a second?
Second.
Is Representative DeSimone. Any further discussion? So the amendment we just passed is now the bill, but we have to vote it again. Anybody? Would the clerk please call the roll?
Chairman Pearson.
Yes.
Representative Long.
No.
Representative DeSimone.
Yes.
Representative Bickford.
No.
Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
No.
Representative Levesque.
No.
Representative Petrino will be voting no. Representative Perez not here. Representative Gregg.
No.
Representative Gibbons.
Yes.
Representative Raymond.
No.
8 to 7.
8 to 7, and would Representative Seidel please prepare the committee report? And we'll be
doing a minority report unless somebody wants to do one. So there'd be no minority.
okay. as you wish. This ends the executive session on House Bill 1111, and we will break until 1:30. Those of you who need to write reports, please get them in today.
Doing the majority report.
Sit down.
Next week, next month.
When the music stops, please be seated. It stopped. Okay, let's do this. We're going to do a few things out of order here, and I am now going to open the hearing on, no, I'm not. I'm going to open the exec session on 1266, permitting recordings of open family court proceedings. And the chair is looking at Representative Ball for a motion. And she's looking for her microphone on button.
Wait, what?
1266. We're going out of order. Welcome.
Listen, it's easy to confuse me, and you did a great job.
You're welcome. 1266, permitting recordings of open family court proceedings. Chief sponsor is Katab. I'm looking at a few of her bills now because she's seat filling and she's right here. We don't have to spend any money to fly her in. And in the executive session, I'm filling in time here on 262024. The chair now looks to Representative Ball for a motion.
I'd like to, thank you, Chairman Pearson. I'd like to make a motion to OTP House Bill 1266.
Is just should have asked this a minute ago. Are there any amendments floating? I didn't see any either. So we skip down to move. That is Representative Ball. It is OTP. And do we have a second? Any Dem want a second? Want a second? Nobody wants to second. So, okay, Representative DeSimone. Representative Ball, please speak to the bill.
This bill will allow the proceedings, parties to record proceedings that are in an open to the public in the Family Division of Circuit Court. Did you want me to say more?
Okay, anything else? Anybody? Remember, this goes back to sometimes the court recordings are cut off, and through some of the work we did with the special committee on the family division of the circuit court, we found out that does happen sometimes because of machinery, okay? And parties who are litigating pro se may want to remember what they actually said and did. Previous bills on this were way too broad in scope. Some of the problems that arose in previous bills are fixed in line 10 and following: electronic recording or transmission of private communication of others, including bench and sidebar conferences, conferences between counsel and client are prohibited. This is what the judges said has to be, and it makes sense to us. So this just broadens on behalf of many people we heard who were in family court who felt this would be an advantage. The question is, can it be done in such a way that is not disruptive? And in my opinion, the bill deals with both of those. Anybody else? Representative Katab.
Thank you, Mr. Chairman. I echo much of what you just said, and I did want to add that there was a similar bill that was put in the year before last year, and it passed the House on 20-0 consent, and then it got over to the Senate, and there was concern about recording of private sidebar conversations and whatnot. So I did explicitly add that into this bill just to make sure that there was kind of no other potential things. I do want to point out that when something is open to the public, anybody from the public can go in and get a copy of the recording. These are hearings that are open up to the public. However, as you said, we got comments that sometimes the recording equipment was accidentally being turned off. So there shouldn't be any concern about privacy here because these are open to the public and anybody can the next day go into the court and get what the court has available for recordings. This is just simply making sure that if the court equipment fails, the person has their own recording. That's all. Thank you.
Thank you. Anyone else? Saw another hand down this way, did I? Did. Representative Raymond.
Thank you. So I am actually opposed to this bill. I appreciate that care was taken in crafting it for making sure that this isn't going to violate any privacy issues, that these are already open hearings. So that relieves some of my concern that I had over the last version of it, that, you know, kids deserve privacy. And so I appreciate that we're protecting them. My concern with the bill is about chain of custody. For me, there's one thing to make a recording for your own private, personal recollection. You need to refresh your recollection of what happened. You can't get the recording from court for some reason. You don't want to pay, you have it. However, to introduce a recording that someone has made on their own personal recording device with no history of what happened in an appeal or something else, I think is a slippery slope where it is not possible to determine, what kind of editing has been done to these recordings. I also am very sensitive to domestic violence situations and cases where someone might take their own personal recording, cut and splice it, and because it's theirs, they can do what they want on it, and post it on social media and use it to harass or otherwise try to control and exploit an ex for whom they have contempt. And I just, for those two reasons, the chain of custody issue and the potential for domestic violence, I just can't support it.
Representative Gibbons.
Thank you, Mr. Chairman. The email that we received from the New Hampshire legal assistance says that they are opposed to the bill because you can already record the proceeding. You just need prior permission from the court. So I'm not sure where this bill is necessary. And I can confirm that it is written on the judicial branch website in the court rules that you are allowed to record, because I read it on there before. With permission, yes.
Okay, if that being the case, I personally am not opposed to passing a law that just underscores what's already there. I do that across the ideological spectrum. I tend to be more is better. Representative Katab, you're the prime, so how would you answer that?
Thank you. So to respond to both kind of things that were said, one, this doesn't say that this is admissible or can otherwise be used in court. This just says that you could make a recording. It doesn't in any way say that it's admissible or that you can use it to create transcripts. Regarding that, yes, you can already do it if you put in notice in advance, but we heard from some people, that if something's going away that they didn't expect it to go, and suddenly in the middle they're there pro se by themselves, they want to be able to record it just for their own. I didn't expect this to happen. I now want a copy, and they didn't foresee needing a copy in advance, so they didn't ask for permission in advance. I just, if it's your part, if you're part of the proceeding, I just think you should be able to record it. But in terms of the comment on splicing, I mean, somebody could do that with the court's copy as well. So I don't think that this is going to change either of those things. I think this is just allowing somebody to have their own personal copy of their hearing that they're a part of.
Representative Gibbons.
Thank you, Mr. Chairman. And I do appreciate Representative Kutab's take on it, where you might decide that you need a recording after or during your hearing. And so if you lost the opportunity to request to be able to record, you might still want that avenue open. That opens up to my next question, where New Hampshire legal assistance recognizes this bill raises concerns about how the Supreme Court will decide which recording to rely upon for appealed cases. So I wonder if we should amend this to say that the courts, because this would address not only Caitlin's point, but also Representative Raymond's point, where if we're concerned about the editing might happen and how evidence might be tampered with if multiple parties can record, then we should make a caveat saying that only the court's recording is admissible for appeals. And so would we be open to amending it to put that in?
Representative Katab.
Thank you for the question. Thank you for recognizing me. Thank you for the question. You know, I think if for some reason the court's equipment had failed to pick up something that was important, I think the court, you know, has the ability to decide if something has otherwise been tampered with, or potentially, you know, if again their recording equipment failed for a certain period of time. I think you can be able to tell a lot of these things based on the fact that, you know, if the hearing, you know, opened at 1:01 p.m. and ended at, you know, at 2:01 p.m. and we only have 49 minutes of recording, that obviously that there was something missing there, you know. And I mean, there are obviously laws on the books about falsifying or submitting false things. So I really don't foresee that necessarily happening. And I think the court can decide rather to accept the evidence or not. Nothing is saying that this would be accepted or would be admissible. I think that I wouldn't want to tie a judge's hands one way or the other. I think the judges can decide whether or not to accept something. And certainly, typically, they're going by transcripts that are kind of coming out. So if somebody disagrees or says that something's missing in there and asks the court, hey, can you look into this? I think there are plenty of ways of verifying if a recording's been tampered with or not. I mean, look at CNN going through and geolocating exactly time and dates of things that happen. So,
Representative Gregg.
Thank you. I have a two-part question. Is that okay? Can I just ask for a follow-up at
It
the
is
beginning?
okay.
Thanks. So on the electronic recording or transmission of private communication of others, including bench sidebar conferences, so we've already unleashed them to be able to record. Who's going to monitor the fact that they're then turning it off if there's like a sidebar? Because, I mean, there are recording devices now that can pick up pretty far. So how is that going to get policed? Because that's obviously a big...
Who's to say you can't do that now? If indeed it is licit to do such,
Well,
how's that happening
but you
now?
have to have permission. So a lot of times when the judge is giving permission, he knows then who's recording, and he can say, you need to turn that off right now. And he can observe that, he or she. I should not.
There are women judges
Yeah,
now.
there are that. So that's one thing. I mean, I have a great respect for this bill. I understand the reasoning. We certainly have heard things. I also have a great respect for our judicial system and the judge's ability to mandate over their own court. And they certainly should have that position to be able to make the decision whether or not somebody should be able to record, because we've seen in real time somebody record their proceedings and then use it as a weapon and post it online. That's been a problem. And whether or not the judge has known that is something else. But the judge should have the ability to control their own court room, in that as far as who's, you know, the behaviors and that kind of stuff, to help keep, you know, some kind of control over a very volatile situations. That's why I will not be supporting this bill.
Representative Gibbons. Okay. Representative Long.
Thank you, Mr. Chairman. Just with respect to the line 6, the recording devices used by the party does not interfere with the proceedings. Is that exclusively on the judge? Can we assume that? It is. Okay.
Anyone else? Representative Bickford.
Thank you, Mr. Chairman. I don't think I have any problem with the bill, because it pretty much matches what I think goes on now. I'm not sure why we need it, but it is nice to tell people what they can do sometimes, as long as a judge can make the decisions. And this bill, it doesn't look like it supersedes anything that the court already has in place. So I don't see any damage by it. That's my spiel. Oh, and I heard about domestic violence being, are those proceedings closed, or are they open? I thought they were closed, but I haven't been lately.
Representative Gregg.
So in a divorce proceedings, that's where domestic violence can come up, right? That's not a criminal trial. So there can be, many times there are a lot of manipulations, especially within pro se and stuff with domestic violence. You see that in family courts very, very often, and weaponizing. In a particular case that we've seen recently, that's happened.
Representative Long.
Yeah, just for clarification, currently, you need permission from the judge. This
Yeah.
bill says you shall be able to, so you don't need permission from the judge,
Oh, really?
right? Is that correct?
But I thought the last,
Well, it does
the
say that,
last
but it
paragraph
says,
cleared that up, I thought. Wherever I did with it. Nothing in this section shall prohibit a party or non-party who is otherwise authorized by law or court order to record proceedings from doing so. So doesn't that kind of flip it the other way?
Representative Katab?
I think the judge still has the discretion, because it does say that, it can't be interfering with the proceeding, which would be at the discretion of the judge. So I think the judge would still have the ability, if for whatever reason they felt that it's interfering with the proceeding, to be able to stop the person.
The fact that about 85% of the litigants in family court are pro se. And if their hearing is continued and they're wondering, what did I say? What did the other side say? I don't know what to look for with the scrutiny of a lawyer. I need to go back and listen. Did anybody remember what I said or what they said? This gives that opportunity. When we were taking lots of hearings on family court, even allowing for people arguing out of anger because they lost the case, even allowing that, it just sounded like there were too many instances where certain judges really didn't want any recordings done. And that seemed to me a violation of people's rights. That even, as I say, discounting a lot of disgruntled people, it sounded like certain ones did not give permission all that often. This gives, to me, a civil right to the pro se litigants. Representative no, that's Bigford. I'm one person behind. Gibbons.
Thank you, Mr. Chairman. I remembered what I was going to ask.
Okay.
I'm not sure what the answer is, so if anyone does know the answer, please pipe up. When we talk about the court transcript, is that in writing or is that the recording, the audio recording? I would expect it to be the writing, but I'm not entirely sure.
Representative Katab, you've
Thank you,
gone-
Mr.
gone
Chairman.
deep.
It is the written transcript, which is authorized to be prepared by one specific company that the court has approved to prepare the transcripts, and it's not automatic. Those are privately paid. If you want the transcript, you pay for them to generate the transcript, this company.
Seeing no further discussion, the motion before us is on House Bill 1266 FN, moved ought to pass by Representative Ball, seconded by Representative DeSimone. Would the clerk please call the roll?
Chairman Pearson,
Yes.
Representative Long, Representative DeSimone, Representative Bigford,
Yes.
Representative Katab,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
No.
Representative Levesque, I don't see present. The clerk will vote no. Representative Perez, I do not see her. Representative Gregg,
No.
Representative Gibbons,
This is a tough one for me. I'm going to say no.
Representative Raymond.
No.
We have 8 to 6.
moved this, oh, I have it down here. Yeah, Ball, I'm skipping a line. And if you would have the Representative Ball, if you would have the blurb for the clerk in the next 2 seconds, please. Brilliant. Actually goes to me. Okay. Next, this concludes the exec session on 1266. Opening the exec session on 1263, again, because the prime sponsor happens to be here in a seat-filling capacity. Parenting coordinators in high conflict cases, 1263. And do we have amendments?
I do.
We have I do. And that would be 476?
476, yes.
Is there another amendment? I thought I heard another amendment floating around.
Yeah, there's only one, I believe.
Only one? Okay, just want to make sure, because we only get one bite at this. Representative Long for a motion? Yes, what?
Yeah, it was handed out.
Amendment. What is the number?
House Bill 1263, Amendment 0476. Does anybody have, not have? Oh, look at that, it just snuck out at you. So Representative Long for a motion on the amendment.
The amendment on,
Come on, guys, settle down. Representative Long.
thank you, Mr. Chairman. I move amendment 0476H ought to pass.
Anybody need one, put your hand up, because we got extras. And who
On
would
the amendment,
second
yeah,
this
yeah, I'll
amendment? Anybody? Yeah, Representative Greg. And Representative Long, would you please discuss the amendment?
I will.
Thank you.
Thank you, Mr. Chairman. The two differences is one, with respect to the training, it adds domestic violence to that training. And that's found on line 5 of the amendment.
Okay, and where is that where does that slot in the bill?
In the bill, it's
Why, line 18.
1263.
I already found it. It slots in at line 18. Line 18 in the bill has techniques, mediation, and legal issues, and line 5 of the amendment adds domestic violence. Okay?
Yeah.
And the other change.
And the other change is with respect to the if the parties object to the appointment, actually line 13 on the amendment, if the party objects to the appointment, the court shall appoint a different person within 7 days after the date of the party's objection. And in the original, which I'm looking for now.
It takes out the words "or confirms."
Correct.
Confirm.
Yeah, those are the only two changes to the original bill.
I recall these were the two issues we had when we heard the bill.
Yeah.
Originally.
Okay.
Yeah. Yeah, the part of Representative Long is being played by.
Yeah.
Any other questions for the vice chair on this? Yes, Representative Raymond.
Thank you, Mr. Chairman. I just have a question. What happens, because my understanding is there's one person who does this right now in the state. So what happens if there's not a second person? Or do we pass the law first and then hope that courts then now create these positions? I guess that's, I'm just worried. Because I like the idea. I really like the idea. Do we need infrastructure first, or we do the law first and then infrastructure comes after?
Well, sometimes the law nudges people to put in place what the law tells. So,
Yeah, so, I mean, I can respond
Yeah,
to that if you like.
please do.
So there is one person in Nashua that we've heard that is doing this currently. Our understanding, though, in testimony is that because it's not just attorneys, it's other professionals, that they would step up to do this. So that's the hopes that there will be more circuit courts utilizing this. You know, we heard in testimony that that works great in high conflict situations. So we're hoping that professionals will step up to do this mediation.
Right. Thank you.
Anyone else? Representative Gibbons.
Thank you, Mr. Chairman. Also, with there being a fiscal note attached, they could just, they could appropriate funds for more positions of parenting coordinators if they needed to. I believe.
Representative Gregg.
Yeah, so one of the things in our special committee that we kind of listened to and that we saw within the courts too was our gal has been a great resource. However, one of the probably biggest disservices we did was not funding that anymore, because we have a lot of our indigent families that could really use this. Now, what this does is not only brings another aspect where we have other areas of expertise besides law and training to help with, helping to get the parents some kind of, help by doing this, but also it provides that maybe the mediation fund and such could be used. Now, I don't think this is necessarily a perfect bill, but I think it's a great step in the right direction as far as helping the families that need it the most.
Which is why you were a co-sponsor. Yeah. Anyone else? Seeing no other hands, the motion before us is Amendment -0476 to House Bill 1263. Moved by Representative Long, seconded by Representative Gregg, who thinks it's pretty good. And when the clerk is ready, please call the roll.
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone. Representative Bickford. Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque is not present. Representative Petrino will vote yes. Representative Perez is not present. Representative Gregg.
Yes.
Representative Gibbons.
Yes.
Representative Raymond.
Yes.
14-0.
The chair will now entertain a motion on ought to pass as amended. He's looking for friends.
Representative Katab?
She
Will I have
can't.
help?
She's writing the blurb.
Yeah.
Okay, thank you.
I'll move on to pass OTPA.
OTPA, and let's have a Republican, can we? Why, that would be me, seconds it. And away we go. Any further discussion? Seeing none, would the clerk please call the roll on the motion OTPA as amended, easy for me to say, by 0476. Moved by Long and represented and seconded by me. Please call the roll.
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone.
Yes.
Representative Bickford. Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque is not present. Representative Petrino will vote yes. Representative Perez not present. Representative Gregg.
Yes.
Representative Gibbons.
Yes.
Representative Raymond.
Yes.
14-0.
Representative Long, ably assisted by Representative Katab, will write the blurb and get that to me shortly, please. This is a second committee bill, so it doesn't go on consent. So that is long. Okay. Good. I like that. This closes the executive session on House Bill 1263, and we now open an executive session on House Bill 1006 on family parenting time. I think there's an amendment floating about. An amendment 0448H, bearing the names of Greg and Kutab, sitting side by side. And one, or indeed any, may move the amendment. Actually, Representative Kutab cannot. But Representative Gregg can. Yes.
I just moved to adopt the amendment. Well, that's what I'm doing.
And you
I move to adopt the amendment 0448H for 1006.
Is this because you had a Dr. Pepper for lunch?
It's because I shoved my food down so quick, my body's like, whoa, what are we doing?
But you've recovered well.
Doing my best.
Who'd like to second? And that would be Representative Grossman. Discussion. What does the amendment do? And now Representative Gregg or Kutab could tell us what the amendment does.
Okay, so on the original, we talked about visitation and custody or visitation. We changed it all to just parenting time. So you'll see, relative to just parenting time in Representative Kutab's conversations with Judge King. This seemed much more doable as far as the courts. We certainly don't want to backlog the courts or anything, but we also want these parenting situations like this to be handled quickly before children are without their parents for months. So this is only about parenting time.
Anything else? Representative, I'll get there. Gibbons, thank you to my
I would like
friends.
to make a motion. Oh, we do? Sorry. Okay, never mind. Sorry.
Well, you might like to, but there's already one on the floor, dear.
Okay, then.
Okay.
I will sustain.
You like that one, do you?
Yes.
Okay, you can vote yes in a minute then, if you like it. Thank you. Far be it from me to, So the fact that it replaces section 1, as I look at the original bill, section 2 is just the date of taking effect. So that doesn't change. And as I'm trying to do a side by side here, I don't see a whole heck of a lot of difference between the bill in its origins and the amendment. Could somebody point me out a few lines, Representative Gregg? Thank you.
Sure. So on the first main line where it says in the event of non-compliance, so after the comma, under this chapter, comma, instead of including, we change that to relative to. And then denying or interfering with, and where it says visitation, we've taken that out and put parenting time instead of visitation. So also down on part 4, letter A, I'm not even gonna pronounce that word right now. So instead of visitation, we have parenting time. So custody or visitation has all been changed to parenting time on line 4. So this is only dealing with parenting time.
Okay.
If we had to deal with all the others, it would be a problem for the courts.
And everything else is the same. That's all it is. Yeah, it looks very nice. Thank you. It's cute. Yeah. That's a computer, right? You have there? Uh-huh. Anybody else? Representative Bickford.
I think it's pretty minor, but on line 18, in this case 20, it brings back visitation in rather than parenting time.
Say what?
That was something I pointed out for the amendment. And that's the only thing I see.
I don't even see that. What do you see? Tell me again. Of the bill or the amendment?
The amendment.
20 on the amendment.
Line 20. A
Okay, it has the
compensatory
word
period of
visitation in both. So it should say parenting time. This, I think, can be fixed somewhere. If,
Yeah, you might be right.
now this can be fixed. I mean, we can go forward. How do we, sometimes in enrolled bills or something, I mean, isn't there a funny little process where they can fix their error?
Yeah.
I think
Yeah. Go ahead.
if we have a few more bills, I might be able to call OLS in the meantime and just ask if they could fix, because we did put it in our red line for them to fix and they just missed it. So if they could just expedite fixing it and give it to us, if you want to recess this and go on, since we have other bills.
I
think
can
we should-
recess this. Sure.
I can call them.
If you want to give them a call, I promise not to have any fun here while you're out doing that. And tell them to do that. And please, then, when it's done, you gotta muscle it over to the 4th floor, which does something with it, and it comes down here. And I've seen that done in 20 minutes. In my last committee. Yes.
Or could we submit a floor amendment? It'd be a no-brainer floor amendment. Right, it's going on a regular calendar because it's an FN.
Oh yeah, that works.
We could do that.
Yeah, that
You've
works.
been here longer than me. Yes.
Yeah, let's do the floor amendment.
Okay.
In the interest of time. I think we'll all agree to that floor amendment. So it should fly right through.
Happy? Good. Let's do that. Thank you. What a team. Any further discussion? Seeing none, the motion before us is the amendment 0448 to House Bill 1006, moved by Representative Gregg and seconded by Representative Grossman. Would the clerk please call the roll?
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone. Yes. Representative Bickford.
Yes.
Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque is not present. Representative Petrino will vote yes. Representative Perez is not present. Representative Gregg.
Yes.
Representative Gibbons.
Yes.
Representative Raymond. 14-0.
Chair now entertains a motion OTPA. Representative Gregg.
I'd like to make a motion to OTPA House Bill 1006, FN.
And seconded by Representative Panic. Any further discussion? Motion before us is ought to pass as amended. House Bill 1006, amended by 0448, moved by Representative Gregg, seconded by Representative Panic. Would the clerk please call the roll?
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone. Yes. Representative Bickford.
Yes.
Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball. Yes. Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Petrino will be voting yes. Representative Gregg.
Yes.
Representative Gibbons.
Yes.
Representative Raymond,
Yes.
14-0.
And the blurb will be written by, fortified by her Dr. Pepper. We'll dash out a great one. All right, comes over to me pretty soon. Thank you. And this concludes the exec session on 1006, making a lot of headway here. I'd like to now open an executive session on House Bill 1667 FN, which is establishing a separate Department of Children, Youth, and Families, separating DCYF out of DHHS. And the chair moves ITL. And I'll speak to my motion.
I'll second it if you need a second.
Oh, yeah, we got to do that, don't we? Who was that?
Raymond.
Yeah, okay.
Sorry, I spoke out of turn, Mr. Chairman.
No, that's fine. No, that's good. ITL, Pearson and Raymond, we're good. All right, here's the deal. There is simply nothing to be gained by separating out DCYF from DHHS, and there's a few things to lose. Much of the testimony on this bill by Representative Hole concerned needed improvements in DCYF, such as accessibility, transparency, and accountability. And you may recall at that point I said those are wonderful things. But first, they're already working on them. And secondly, doesn't matter whether DCYF is independent or not, they're still going to be working on them. So much of his testimony was wonderful, but not really relevant to the motion of the bill. After years of seeming mismanagement and public outrage, the present director's predecessor, Joe Ribson, was brought in to clean things up. The measures he took are now being enhanced by the present director. We saw him this morning, Jeff Fleischer, who heartily acknowledges the needs mentioned in the testimony for further improvements. And this is demonstrated by his continual work on them. This work will continue, and it does not need DCYF's detachment from DHHS for this to happen. DCYF regularly makes reports to the Children's Oversight Committee, and since it's under DHHS, it periodically makes reports to the DHHS Oversight Committee, which I chair. The Office of the Child Advocate regularly works with DCYF. The Special Committee on the Family Division of the Circuit Court, which I also chair, learned the regularity with which family court intersects with DCYF. CASA works with DCYF. DCYF's director regularly attends meetings of the governor and council, and there's more. The director regularly gets calls on his cell phone and passes them along to his staff for follow-up. Besides such constituent relations, the director regularly leaves his office to meet with various stakeholder groups. I've asked, and he's named some. Again, this work will continue, and it does not need DCYF's detachment from DHHS for this to happen. The vast majority of other states place their DCYFs under their Departments of Health and Human Services. To do the work of separating out DCYF from DHHS would require a considerable amount of money for no other apparent gain than just separating. And this is money better spent in further strengthening and enhancing the staff at DCYF, and make more difficult the synergy, staff sharing, and data system syncretization now enjoyed by DCYF being in DHHS. And this is true in many other states, and it is true here in New Hampshire. So that's my motion. And why? Any further discussion? The motion before us is ITL, on House Bill 1667 FN, moved by Pearson, seconded by Raymond. Would the clerk please call the roll?
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone. Representative Bickford.
Yes.
Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Levesque is not present. Representative Petrino will vote yes. Representative Perez is not present. Representative Gregg.
Yes.
Representative Gibbons is not present. Representative Raymond.
Yes.
Okay, 13-0.
How many?
13? 14, excuse me.
No, I take
14,
it back.
15,
No,
16,
sorry,
17.
Gibbons is gone too.
Yeah,
Yes, sorry,
14.
sir. 13 zip. I'm not sure what to do. It has a fiscal note, but it's dead. So can it go on consent?
What if it's overturned?
Right, 13.
It doesn't go anywhere now.
16.
All right. Any objection to consent if it can be on consent? Seeing none, it's on consent pending approvals of higher ups.
There is a fiscal note on that.
Yeah, but it's not going to a second committee because
Okay,
it
'cause it's been.
died here, I think. Anyway, here's my blurb. Okay. Thank you. Yeah, we'll find that out, and if it has to go on to consent, off consent, it'll go off consent. And this ends the hearing on, whatever that was, 1667. It wasn't a hearing, it was an exec session. I'm opening the exec session now on 1425 on no suspension of a driver's license in child support enforcement matters. Chief sponsor was Representative Bernardi, 1425. Does anyone wish to move this bill? OTP.
I move to OTP for this bill.
Okay, Representative Panic moves OTP. Is there a second? Representative Bickford. Any discussion? Representative Bickford. Microphone. The sponsor says there's no amendment.
Huh?
The sponsor told me there is no amendment
Oh,
coming
okay.
from him.
The, well, I'm up in the air on the bill.
And yet you seconded it.
It is, well, it's just the driver's license, as I recall. I think it's a very draconian move to do such a thing as that. I was here in I think it was 1995, when this passed, along with hunting licenses, fish and game, that sort of thing. And I've always been opposed to it because we don't collect money from anybody else in the same manner. And I always said, everybody needs to be on the same level. I especially know that because I've lent money to people and had to chase after it. And I really would have loved to be able to take their driver's license away from them. They get that money back, especially when my daughters needed braces. So I think we should all be on the same playing field as far as collections. It just doesn't make sense.
Are you
I know
arguing against the
it's a-
motion you just made?
Huh?
Are you arguing against the motion you just made?
What did I? No.
You seconded the OTP and you're arguing ITL. I just want to
No, I'm
clarify.
not.
You're not.
Are you for or against the bill, sir?
I'm for the bill. It's
Oh,
about
okay.
stopping from taking driver's licenses from people. And the reason,
That's scary.
I thought I had you for a minute.
oh, is that right?
He's so innocent.
You want me to start over? Really?
You would like an amendment that would grant you permission to take people's driver's licenses away who owe
Yeah,
you money.
I do not want driver's license taken because, and my reasoning is because no other place in society that I know of, do we take driver's license away from people for owing somebody money. And I'm saying, I would have loved to have that for myself, to collect money from anybody, because you know what? I've had kids to support, or pay for braces and things like
Braces,
that.
yeah, braces.
On the other hand, my question is, what is the cost of this? And maybe that's only for finance committee, I don't know. But the feds may come down on us heavy. I don't know. When Susan Brisson spoke to this the other day, she said, well, there are ways of doing it softly. Maybe that was the word. And that's really what I expected for an amendment. But I really want to get at least a discussion on it and maybe get more information. So that's why I agreed to second it.
Okay, anybody else? Representative Raymond.
Thank you, Mr. Chairman. So I also had written down, I think what Representative Bickford was referring to. I have a note from, I think it was Attorney Brissons who had spoken to us, that if we pass this, it might impact our TANF block grant, because other states have exceptions, but they don't have nothing, right? And so I'm concerned if we pass it without any kind of amendment that would give us exceptions like what other states do, that it might impact our TANF block grant, which will impact significant funding for a lot of our programs, including child support. And I Googled and I got nothing. So
Maybe we could.
Does everybody have this memo from our committee researcher? Because it outlines what other states do. And I see some states have exceptions, but others don't. And I don't know if their federal money has been withheld. It is a research project dated February 1st.
So, Mr. Chairman.
Yes.
But I didn't see and I did read this, I didn't see that there were any states that just said a blanket, we're no longer going to impact the driver's license. What I saw was all of the states have some impact to driver's licenses based on noncompliance, and that if we pass this, we would be the one state that has no impact on driver's licenses. And so there's no telling what that will do. Like, there's nothing to compare it to. I mean, I don't know what TANF will do. So I guess that's my question, is if we forge ahead and do this on our own, what's TANF going to do to our funding? And I don't know who answers that question.
Representative Gregg.
Am I wrong?
Yes, so all 50 states have something with this. And what they talked about in here with this is if we decide that we're going to say, okay, well, we're not going to do this with the driver's license, there's a certain federal government thing that they require us to do. We will not be in line with that anymore. This could be a big problem. All 50 states do the driver's license, so this is going to be a problem. Each state is required to have procedures. So it says right here, Department of Health and Human Services states that there may be significant fiscal impact to the state since as a condition of receiving federal 4D funds, each state is required to have procedures regarding the withholding, suspension, or restriction of the licenses of non-custodial parents who owe past due support.
What I'm seeing as I flip through the report is every state seems to have a stated reinstatement policy. And it is your statement that we don't in this bill. Is that correct?
Yes, I'm saying that we would be completely out of line with all 50 and the federal government's requirement if we no longer did this with driver's licenses.
And a reinstatement policy in the law covers that concern because there's a way to state it to go about and get it back?
We currently have a reinstatement policy for getting their driver's licenses. They're able to get their driver's licenses back. We have a warning period. They have 20 days to file something saying that they're going to do whatever or pay a couple dollars. We were told over and over that it's not this instant thing. They have time and they're warned and they have the ability to contact and say, we're going to do this. It's for habitual abusers of the system that continue to not pay. I mean, once again, we're looking at the best interest of the child in being able to get funds. And this is like this is really one of the last resort things. It's not like they're like, okay, you know, you're late one time, we're going to take your license away. This is for people that they've been unable, and they did say that they've successfully gotten people to pay, you know, or at least start paying, and then they're able to have their licenses. But it's very rare that they actually do this. My bigger concern is, you know, the money from the federal government and us being out of line with that.
I do not see that point. I'm willing to learn it, but I'm looking through this printout of every state, and every state has the delinquency threshold at this point for this many days. We're coming for you.
Right.
And then everything has a reinstatement policy on how you get it back.
Right. So,
What do we not have?
So, Mr. Chairman,
Yes.
this bill would take away the first half of it, which is we would no longer take away licenses, because that's what the bill prohibits us from doing. The bill says you are prohibited from, let me read it, taking away. So we would no longer have a reinstatement process because you can't
nothing
take
to
it away.
reinstate. Okay.
And by getting rid of the taking it away and the reinstatement process, based on the fiscal note, which I have now refreshed my recollection, that would put us out of compliance with the state plan requirements as outlined in Title 4D of the Social Security Act. And if we are out of compliance with Title 40 of the Social Security Act, the last page of our paper here says that the total loss of operational funding for New Hampshire's child support funding could be $16.9 million in federal fund, $1.2 million in federal child support performance funds, and $1.9 in the federal TANF block grant funding. So I guess I was hoping to see, in order to pass it, an amendment that would say, you know, that would change how we revoke it. But if we entirely remove the requirement to revoke a license and have a way to get it back, then that is going to cost our state, it looks like 17, 19, $20 million. And that, to me, I just can't do it.
On page 2 of the memorandum that we've been looking at here with all the states, it actually has the federal law here. The states authorizing suspension of licenses. So it's actually on the second page, the federal law.
Okay, is it page 2? All right.
Yeah. So while I might personally have feelings about it, I think I don't feel so strongly that I'm willing to risk $20 million.
No. Representative Long.
Thank you, Mr. Chairman. And what I have a hard time with is those that are currently without a license because of child support, they'll be getting their license back, whether they've been paying up their arrearage or not. This bill allows them to get their license back. And that's a concern of mine.
Anyone else?
Yeah,
Representative
I guess.
Bickford.
Well, I'm curious as to how much, I had asked this question at the hearing, and Attorney Susan Burson gave us some kind of an indicator, and I've always wondered what would it cost us to actually do something about it. And she's actually the one that brought up the softer approach on the driver's license, because I think I'd like more information on it. I know when we did the mandated wage assignment, they came up from Boston actually and told us, you do this and it's $21 million. So not giving us any more money than we did 20 years ago. But sometimes there's a way around things. So, but anyway, I wonder if we can get a little information from the child support attorney that's here.
She was sitting there so patiently. and was doing research while she was.
Well, unfortunately, I'm not sure I have any more information, at least on that area, in that we would definitely need to speak to DMV and find out how they deal with, because it's sort of a joint thing of we tell them and then they do that. So I don't know if that's a thing that they do. We'd have to come up with a new system to be able to do that. But that is something, a restricted license is one of the things that is allowed under the, under Title 4D. It's procedures under which the state has and uses in appropriate cases authority to withhold, suspend, or to restrict the use of driver's licenses.
We're looking, if I may, for the cost to the state. I mean, we know the full cost could be as much as $20 million, but it's, sometimes they just take a portion of something. You know anything about that?
That I don't. We haven't had, thank goodness we haven't had to deal with that recently. The only minor fact that I know is at one point several years ago, Idaho wasn't going to pass the new UIFSA statute, and the feds came down on them hard and quickly, was what I was surprised at.
Oh.
So, but I have no idea.
Okay, thank you.
I have in my notes 42 USB 666A16.
Yes, sir.
And the note is, we have to suspend various licenses, including driver's licenses. Is that a correct citation I made?
Yes, sir.
And do you have it in front of you?
I do.
Of course you do. Would you read it, please?
All right, starting at the top. In order to satisfy Section 65420A of this title, each state must have in effect laws requiring the use of the following procedures consistent with this section and with regulations of the Secretary to increase the effectiveness of the program which the state administers under this part. And then Part 16 says authority to withhold or suspend license. So it requires procedures under which the state has and uses authority to withhold, suspend, or to restrict the use of driver's licenses, professional and occupational licenses, recreational and supporting licenses of individuals owing overdue support or failing after receiving appropriate notice to comply with subpoenas or warrants related to paternity or child support proceedings.
So there. Uncle's watching.
As far as I know, only once in my 23 years have we actually attempted to take the license of somebody who refused to show up for paternity testing.
And your testimony has been usually the threat is enough to scare them.
Can be. I mean, it's the first time you can sort of get them to talk to you if they're not paying attention to all of the voluminous mail that we send.
Well, what do you think, folks?
Want to withdraw the motion?
You can withdraw the motion if you wish. Withdraw the motion in the second, that's fine. It takes courage to do that after you've made a motion when new information is forthcoming. So thank you very much for that. Now, would somebody like to make another motion?
I'll make that. Oh, go ahead. You can do it. Oh, I guess I'll write the report then.
All right, one verse of, we'll sing one verse of Kumbaya. Okay, so the chair recognizes Representative Raymond for a motion of what?
ITL, please.
ITL, and seconded by
I second
Representative
that.
Panic. All right, you get in there. Any further discussion? Seeing none, would the clerk please call the roll? The motion is ITL on House Bill 1425 FN.
Chairman Pearson,
Yes to ITL.
Representative Long,
Yes.
Representative Desimone, Representative Bickford,
Yes.
Representative Katab,
Yes.
Representative McMahon,
Yes.
Representative Ball, Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Petrino will vote yes. Representative Gregg,
Yes.
Representative Raymond.
Yes.
Did I miss anyone? Okay. There We have it. 13-0.
13-0, the motion ITL passes. Representative Raymond, could you come up with a committee report for me, please?
Yes. Thank you.
I'll take that as yes. Thank you. And this ends the exec session on 1425. It said FN, but it failed. So let's, any difficulty with consent? If we may do it, fine. If we don't, we can't, then it goes away, but we at least put our oar in the water. Any objection to consent pending? Okay, yes, Representative. Oh, we can fill something in a half an hour. Would you like me to proceed with your last? All right, 1564, please. And I think everybody's figured out it is very similar to the subject of 1595. So 1595 from Representative Bickford is the prime, and 1564 with Representative Katab as the prime. And what we can do is open the exec session on one of them, and somebody make a motion accordingly, and then I can put that into recess, open the second one, and what that will give us is a chance to do things in parallel, discuss the relative motions of both. We may decide to kill both, pass both, or do one and one. So Representative Bickford, would you like to make a motion on 1595?
Make a motion ought to pass.
Ought to pass is the motion on. We're doing actually both in a row. Just hang in there. Motion is ought to pass by Bickford. And now we're going to put that into recess, and 1564, Representative Katab's, Representative DeSimone for a motion.
I'd like to motion OTP on House Bill 1564 FN.
So now we have two bills in play because they cover the same things. Representative Bickford, would you speak to yours, please? Yeah. Okay, thank you. 1564 seconded by Representative Long, and 1595. A second? If there's no second, it dies. You don't have to do it, but you may.
What's 64?
On 1595, I'm looking for a second. That is your bill.
Oh, no one wants to second that?
All right, Representative Panic seconds it.
Wow.
And now we may discuss both bills because they're plowing much the same territory, but there's some different numbers involved. And you and I have gotten emails from national groups on both sides of this. Representative Bickford, make your case, please.
Well, this bill has been asked for more than 20 years from the Department of, from the reviews that the Department of Child Support Services has been doing over the years. They do these every 4 years. I will read a short paragraph from the 157 of the recommendations. Is adopt a time-sharing adjustment. The high guidelines deviation rate and the recommendations from survey respondents speak to the overwhelming need for New Hampshire to adopt a statutory formula. New Hampshire is currently one of the 9 states that does not provide a formula in their guidelines. Many of these states are also in the process of adopting or considering adopting a time-sharing formula. When adopting a time-sharing adjustment, the guidelines deviation criteria should also be revamped. many of the deviation criteria relate to time sharing. So this report, like all the others, as I pointed out, $116,000, this is a state report. It's not by some organization or anything. It's done for the state and is contracted every 4 years. And so the state, the child support time sharing is what you have before you, is a parenting time adjustment. And it will satisfy all those demands. Don't think what else I can say. I do have a pro and con if you want, or you.
Yeah, you got a couple more minutes. Go ahead.
First, the major recommendation of the quadrennial review, which is this, was to implement a formulaic parenting time adjustment. 1564 proposes a presumptive zero order in the very narrow circumstance when both incomes and parenting time are equal or approximately equal, if and only if both parties first agree to evenly split add-on costs. In contrast, 1595 provides a broad formulaic adjustment for any mix of incomes, parenting times, and add-on costs using a parenting time formula adopted by many of the other states and supported by judges, attorneys, and parents in the survey conducted as part of the quadrennial review. The need for a broad rather than a narrow formula is reflected by data that shows parenting time situations are approximately evenly split between lower and higher parenting time situations. Additionally, HB 1564 proposes a complex deviation mechanism for the majority of situations occurring outside the zero order, which would increase rather than decrease the already high deviation rate of 48% in New Hampshire. In contrast, the broad formulaic approach of 1595 may decrease the deviation rate by as much as 1/2 based on data in the report. So that's what we're trying to achieve. Second, 1564 proposes to increase self-support reserve 130% of federal poverty line, in line with the recommendations of the quadrennial review. 1595 was unable to include the recommendation due to legislative drafting rules, but would welcome this amendment. However, 1595 does stand alone without that. You know, both bills can be passed and we'll get both things achieved. Third, 1595 incorporates the quadrennial review recommendation to shift child care expenses and medical costs from income deductions to add-on costs to be consistent with the income shares methodology adopted by New Hampshire. HB 1564 has not included that recommendation. So we've got that added in here too. 1595 amends the ability to pay calculation to include direct child costs by the obligor in order to prevent the obligor being inadvertently forced below poverty level. This is consistent with the Federal Modernization Rule Directive of 2016. Fifth, in order to support proper calculation of proposed changes, HB 1595 corrects the proration of child costs beyond base child costs to also include add-on costs to allow a fully functional income shares methodology as originally envisioned. The correction was identified in the 2004 310 Commission report and affirmed in 2019 by the Supreme Court Anderson. So we're taking care of the Anderson Supreme Court decision that says the legislature needs to fix this formula. And that's what it does, to ensure that both the custodial and non-custodial parents share in the support responsibility for their children according to the relative percentage of each parent's income. In contrast, 1564 leaves the current proration mechanism unchanged. In summary, HB 1595 provides a more comprehensive solution for the same cost, while decreasing rather than increasing deviations, which is the direction we need to go in child support guidelines. Additionally, it also resolves a known long-standing flaw in New Hampshire income shares model, which should further decrease deviations by promoting equitable calculations. In short, while HB 1564 has merit, 1595 provides substantially better bang for the buck. In other words, you get a very comprehensive bill here to do a lot for the same cost as anything else that goes before finance.
Any questions for Representative Bickford on his bill? Seeing none, Representative Katab on yours, which is 1564.
Thank you. So this bill seeks to, well, let me take a step back. So in the special family court committee, we heard much testimony on the need to untie the judge's hands, so to speak, because right now deviations aren't allowed in the cases of shared parenting time. And so particularly when the kids are 50-50 parenting time with either parent, and one parent, we had a mom come in that basically said that she was paying so much to the other parent that, he was getting to take the kids on vacation and out to dinner, and she could barely afford to pay her bills, let alone take the kids on vacation or out to dinner. And so with that in mind, I think it's important that we kind of untie the hands, but that we do keep the best interests of the children in mind. And so these are rebuttable presumptions. Rep Ball and I had worked together on the summer with getting together with some of the stakeholders. We've seen that over the past decade with this much needed change, thing after thing has been ITL'd. So we did get together with several family law attorneys from NHAJ. We got together with NHLA. We got together with some mediators, and we tried to see what would work that also wouldn't ruin things for the families that are agreeing, because we've got 80% of families that are agreeing and then the 20% who aren't. So we want to make sure that whatever we do is going to work. And so we were able to come together and reach an agreement on this bill. I think it does many great things. It increases the self-support reserve up from 115 to 130, which has long been recommended to do in the quadrennial report. So I think that this bill addresses many of the issues that we heard about in the special family court committee. And I do think that it will help many families in New Hampshire without lowering the child support so much that we have unintended consequences that we don't want to have. So thank you.
Any questions for Representative Katab? We have two different bills before us looking at the same thing. We can vote ITL on both of them. We can vote one up, the other down, or we can send them both to the Senate and let them have fun. How would you like to proceed? You're mostly.
I'm just confused because we have two bills out. I mean, personally, I would like to see Representative Katab's pass and not Representative Bickford. So I don't know how we go about that.
Well, we have motions on both of the bills, so why don't we take one? The first one was 1564. There was a motion by Representative DeSimone of ought to pass. We'll take a vote on that, and then we'll take a vote on 1595, which Representative Bickford, did you make the motion of ought to pass? He did. Yeah, I thought so. Okay, so
Yeah, I was just going to say, I brought in an amendment for that, 1595, which was a domestic violence thing that Representative Kutab has in her bill, and some people said, well, maybe I'll throw it in that bill too. So when the time comes, we'll.
Okay, yes. So I mean,
I'll pass it around.
If we move them out to pass, then you may want to look for if they're both out to pass, you may want to look for an amendment.
Don't we need to do the amendment first?
Well, yeah, I mean, you may be getting the amendment for nothing. I don't know. But, yeah, you don't know how we're going to vote. So you may not need an amendment. I don't know.
You can do a floor amendment. after we've passed things or whatnot.
if it's that simple.
Okay.
So we were gonna take OTP on 1564. Take a vote and then take a vote on it.
Okay. I just got asked to sub as a chair in another committee. Are you kidding me?
Finance?
Don't Sure. So the motion, recite what we're doing,
I'm sorry,
That's all right.
so the motion is on ought to pass on House Bill 1564 by Representative DeSimone. And if the clerk would.
Okay, we
call the
will
roll.
do 1564 first. Representative DeSimone, seconded by Representative Long. This is Representative Katab's bill. The motion is OTP on 1564. Would the clerk please call the roll?
Chairman Pearson,
Yes.
Representative Long,
Yes.
Representative DeSimone, Representative Bickford, Representative Katab,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
Yes.
Representative Petrino will vote yes. Representative Gregg,
Yes.
Representative Raymond. Did I call everyone? 13-0.
13 zip.
That'd be everyone.
Okay, and would Representative DeSimone hand me, within the next 2 seconds, please, the committee report? Thank you.
I have those.
I emailed it.
Yeah, and this ends the, no, executive session, thank you, I do that all the time. On 1564, and now we open it on, I open it on 1595, thank you, which is Representative Bickford's. Okay, and wow, you got a lot done while I was gone. And this is already ought to pass. Representative Bickford, seconded by Representative Panic. This is on House Bill 1595. And here we go. Chair, clerk, please call the roll.
Chairman Pearson,
Yes.
Representative Long,
No.
Representative DeSimone, Representative Bickford, Representative Katab,
Yes.
Representative McMahon,
Yes.
Representative Ball,
Yes.
Representative Panic,
Yes.
Representative Seidel,
Yes.
Representative Grossman,
No.
Representative Petrino will vote no. Representative Gregg,
No.
Representative Raymond. We have 7. 1, 2, 3, 4, 5, 6. 7 to 6, it passes. Ought to pass.
7-6.
It passes 7-6. And Representative Bickford, if we could have a report on that from you, thank you.
Mr. Chairman, can I ask a procedural question?
You may.
Thank you, sir. What happens when we pass two bills that are slightly in conflict with each other but do the same thing?
They go to finance. Then they go to the Senate by
Okay.
way of the House floor.
Fascinating.
And people can craft floor amendments to either one of these along the way. And that ends the exec session on 1595. I open the hearing. No, I don't. I got to print this out. The exec session on House Bill 1511, Representative Deb Hobson's little bill. It is a kind of a housekeeping item. What it does is ensures that New Hampshire supports the best interest in educational rights of the students and so on by making sure that the Department of Health and Human Services Bureau for Children's Behavioral Health notifies the Department of Education on the date a court order is signed. I mean, it's that sexy, right? It's just that things, the desire of the sponsor, the desire of others, and the desire of, you may remember, Isidore Rodriguez Legendre from the New Hampshire Council on Developmental Disabilities was that reporting wasn't always done, and this will ensure it. So therefore, the chair calls upon himself for a motion that he's already spoken to and moves 1511 ought to pass. Me. And I need a second. Who is I?
Grossman.
Oh, I know that. Oh, you. Okay. So that's the reason. I mean, it is like the ultimate of housekeeping. It just makes sure there's an agency specifically tasked with communication. And you will see that in the boldface lines 10 and 11 in the bill. That's all it does. We had one written piece of testimony by the head of the Council on Developmental Disabilities. Any questions, comments? All right, seeing none, I will call the question. The bill is 1511. The motion is ought to pass. Moved by the chair, seconded by Representative Grossman. Would the clerk please call the roll?
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative Desimone. Yes. Representative Bickford. Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Petrino will vote yes. Representative Gregg.
Yes.
Representative Raymond.
Yes.
13-0.
Yeah. Consent, any objections? Consent. 13 zip. You give me a blank sheet, I'll take this and put on it. All right, this closes the exec session on 15, whatever it is, 1511. And give us a minute here to catch up.
There is it. Okay. I didn't write it down.
Yes to consent. Okay, thank you. We're getting in the home stretch here. Open the executive session now in 1282. Representative Ball's bill alters the time at which a child support obligation ends. There is an amendment by Representatives DeSimone and Ball, Amendment 0453. This is House Bill 1282, and the chair will entertain a motion on the amendment.
Mr. Chairman,
Yes,
I would like to make a motion that we adopt the amendment.
0453.
Yes, 0453.
And a second. Second by Representative Bickford. Thank you. And Representative Ball, would you please speak to the amendment to your bill?
Yes, if everyone recalls, this is the same bill that we unanimously approved last year. We did make a minor change. It came back to us because I mistakenly used the term benefits instead of child support. But in testimony, it was brought to our attention that we should clarify the charter schools and home education programs. So we did include that in here to make sure that there's nothing left so vague as to leave loopholes. If you recall, Chairman, this was closing the loophole
Right.
of when a child turns 18 while they're still in school, but then they choose to drop out of school. And the original bill said it was whichever was later. So they could still be getting child support past the age of 18.
And in the amendment, this is something that I deal with in my work with the developmentally delayed and other groups. Line 16 in your amendment, it no longer just says until the child reaches 21. It adds or no longer qualifies as a child with a disability, which stretches it a bit, which it should.
Yes, that was at a recommendation in the Special Committee on Child Care, where we're trying to get away from putting age 21 now so that we could link it to another bill in case that age should change. It would keep everything uniform.
Any questions for Representative Ball on the amendment? The motion before us is Amendment 0453 on House Bill 1282, moved by Representative Ball and seconded by Representative Bickford. Will the clerk please call the roll?
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone. Representative Bickford. Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Petrino will vote yes. Representative Gregg.
Yes.
Representative Raymond. 13 to 0.
13 to 0. Chair will entertain a motion on OTPA. Representative Ball.
Chairman,
Moves,
thank
yes.
you, Chairman Pearson. I'd like to move OTPA, please, on House Bill 582.
Do we have a second?
I'm sorry, 1282.
Do we have a second? Who seconds this? Representative Gregg. Any further discussion? The motion before us is ought to pass as amended. House Bill 1282, amended by 0453, moved by Representative Ball, seconded by Representative Gregg. The clerk may call the roll.
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone. Representative Bickford. Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic. Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Petrino will vote yes. Representative Gregg.
Yes.
Representative Raymond. 13 to 0.
And Representative Ball, would you get a blurb on that, please, within the next 4 seconds? This really works well. Yeah. This ends the exec session on 1282. Now I open an exec session on 1590, Representative Long's bill, training regarding child abuse and neglect for doctors and nurse practitioners and physicians assistants and so on. And is there an amendment coming?
Actually, if I may,
Yes, you may.
I'll move 1590 interim study. And
It's a legitimate move.
somebody want to second that? It would
Yeah, I'll
be
I'll
forever
second.
grateful.
I'll second that.
Forever
grateful is
if
good.
And if I may.
You may.
Training for medical professionals is an important requirement to ensure an early detection of abuse and neglect in children. It's also important to identify the best training available, which the professionals weren't able to come up with yet. And also the process with which we could log in those that are taking it to assure that it's meeting its goal. And also with training that's updated often, who's going to be responsible for updating the training. So therefore, that group agreed to work with me or whomever gets appointed to there, and I'm more than happy to get on that study committee.
Sure.
So I'll move, that's why I'll move interim study.
The motion before us is 1590 interim study, moved by the vice chair and seconded by the chair. Any further discussion? Would the clerk please call the roll?
Chairman Pearson.
Yes.
Representative Long.
Yes.
Representative DeSimone. Representative Bickford. Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Petrino will vote yes. Representative Gregg.
Yes.
Representative Raymond. Motion passes 13-0.
13 to 0. The blurb by Representative Long. Two.
Oh, here you go. Yeah, it just came out of me.
Certainly. Representative, your committee report is nothing to sneeze at. Oh, we chugging here. Okay, that ends the executive session on 1590. Can you believe we are down to one, I think? And that would be House Bill 1341, liability of grandparents to provide assistance, Chief Sponsor Representative Bickford. Chair will entertain a motion on the bill. I take it there's no amendments. Representative, make a motion.
I'll make a motion of ought to pass.
Ought to pass, Bickford. And who else? Second. Second, Representative Panic. Okay, 1341. And would you please speak to your motion?
Well, this again was a recommendation of the quadrennial review, and I'll read that to you. It's rather short. It says, either repeal the law providing for grandparent liability to support the children of their unwed minor children, or add more specification to it. There are numerous justifications to eliminate it. It is not a common issue. Child support from the parent, if able, should be prioritized, and establishing policies for consistent treatment would require a lot of time and resources for few cases. More specification would entail whether to limit liability only to public assistance cases, applications to both the maternal and paternal and paternal grandparents, identification of income to be used, and several other specifications, which I believe is what I reported to you at the hearing. So, anyway, I'm trying to clean up these recommendations in the review.
Any questions for Representative Bickford? The point of the bill is to say grandparents are not liable now for supporting their grandchildren. Anybody have a comment on this, one way or the other? Representative Raymond.
Oh, I don't have a comment. I just think it's important, and I appreciate Representative Bickford's work getting these things cleaned up for us. So thank you. Thank you.
Oh, thank you.
Good work.
I took that as a comment. Anyone else like it, not like it? Would you like to be recognized, Representative? You wouldn't? Okay, I still recognize you. Okay. I see you right over there. Okay. Anyone else? The motion before us, House Bill 1341, liability of grandparents to provide assistance. Chief Sponsor Representative Bickford moved it. OTP. Panic seconded. Clerk, please call the roll.
Chairman Pearson.
Yep.
Representative Long.
Yes.
Representative Desimone. Representative Bickford.
Yes.
Representative Katab.
Yes.
Representative McMahon.
Yes.
Representative Ball.
Yes.
Representative Panic.
Yes.
Representative Seidel.
Yes.
Representative Grossman.
Yes.
Representative Petrino will vote yes. Representative Gregg.
Yes.
Representative Raymond.
Yes.
13-0.
Any objection to consent calendar? Seeing none, on to consent. Representative, if you get us a committee report, and I'm about to call my grandchildren.
You're on your own.
Good. Yes, you're on your own. All right, 1341, exec session is completed. Thank you all. We did it.
Good job.
I don't have a printer. I won't be by a printer for 2 days. If you could go to the 4th floor and ask him to print it out for you so I can give it to the clerk, please. Could you put in another sentence in effect saying we looked at it but decided there
Thank you
was
very
more we
much.
needed to learn? You know, next to the last sentence. Otherwise, it just sort of gets to a conclusion abruptly. All of which is true, but why should we interim study it? I would suggest a sentence in there, something like that. Well,
Saying like,
while we learned much through the hearings, we realize there's more to this than we, you know, blah, blah, blah. And if you owe a report I'd like your report, please.